यति कुरा नै देखि दुतै लगा অলপ এনেকুৱা কৰি।
Please, Your Lordship.
Yes.
I beg to mention item number 41. Finally, this matter may be listed after 2 weeks, Your Lordship. Yes, Your Lordship. Hearing.
Why? 2019 matter?
Your Lordship, we have another matter, item number 39, which we intend to take it up today for disposal, Your Lordship. So there might be some time constraint also.
See? 41.
Yes, Your Lordship.
2019 matter. Okay. Okay.
I have similar prayer for item 44 also, Your Lordship.
Then,
Item 44.
no. We'll see when the matter is. Let me take up the list.
Yes, Your Lordship.
Mr. Jamili is there.
Yes, Your Lordship.
May I please, Your Lordship? Lordship, I beg to mention item number 49, Lordship.
We'll take it up. We'll see when the matter reaches.
Lordship, the leading counsel is indisposed, Lordship.
Forty-nine. Okay. The request of the learned counsel for the petitioner, matter stands adjourned to be listed when?
After 2 weeks, Lordship.
After 3 weeks.
What's next, Lordship?
For motion, item number 1.
May it please, my lord. Lordship, the petitioner was serving as UDA cum Peshkar at District and Session Judge Dimapur. Lordship, what has happened is that the petitioner unfortunately expired on 30/4/2022. That is at annexure A, page 12, Lordship, the death certificate. The petitioner's husband, I beg your pardon, Lordship. The petitioner is the wife of the deceased.
Okay.
Now, Lordship, my lord will kindly come to page C, page 16, annexure C. This is the notification issued by the respondent government promulgating rules, Nagaland District Court Employees Service Rule 2017, Lordship. Page 16.
Yeah.
Shall I read out, Lordship? In the exercise of powers conferred under Article 309 of the Constitution of India and in pursuance of the direction of the Honorable Supreme Court of India in Renu and others versus District and Session Judge Tis Hazari and Another, the Governor of Nagaland is pleased to make the following rules. The Nagaland District Court Employees Service Rules 2017.
Where is the impugn order?
Impugn order is at letter, Lordship, page 37, annexure I.
What is this? Why are you agreed with this?
Yes, I have impugned this. This is a letter written by the Office of the Principal Accountant General, Nagaland Kohima, respondent number 6, Lordship, to the Under Secretary to the Government of Nagaland obliques Department of Law and Justice, Nagaland Kohima. Subject, pension, family pension case in respect of Let Dethole Chadi, ex-Peshkar cum UDA. Sir, in inviting reference to your letter number so-and-so dated 29/5/2023, I am to return the following documents with the observation mentioned below. 1. As per page 22 of service book, the pay of the incumbent was fixed at rupees 5,100 as on 1/4/2003 and later corrected it to rupees 4,815 as a result of which the incumbent has drawn excess pay and
There's not only a question of excess pay,
no, Lord.
There's a question of excess pay?
No, my lord, my lord can kindly peruse page 38, annexure I1, last page. This is from the department, the
Page 30?
38. It was corrected since 2003. Lordship will kindly see that 4,815. It was wrongly entered as 5,100 in the first place when the service book was opened, but thereafter immediately, Lordship, it was corrected from 2013 till.
No, madam, I'm also asking, is there any question of overstay?
Lordship.
Is there a case of overstay? No. Overstay.
No, Lordship, no.
It's a case of the fixation.
Fixation, no, Lordship, here the question is, they are trying to impose this
They want to make a recovery.
they want to make a recovery, Lordship. When I am covered by the Nagaland District Court Employees Rules to 2017, where I am to retire after 60 years, on reaching 60 years. That is under the Nagaland District Court Employees Rules 2017. I am covered by that.
Now, who is going to retire?
The petitioner's dead husband was to retire, and he was covered at the time when he expired. He was covered by the Nagaland District Court Employees Rules 2017, Lordship. However, the respondent wants the petitioner's late husband to recover the money, as they want to retire, let the petitioner's husband be placed under the Nagaland Retirement from Public Service Employment Second Amendment Rule 2007. That is at annexure E page 21 is the court employees rules. Lordship will kindly see the retirement. Annexure E, page 21. Rule 24. This covers the petitioner's late husband. Except as otherwise provided in this rule, every employee working under the district judicial court establishment shall retire from service on the.
And now as per the new rules,
it
is?
No, that is not new rule. They are confused. Lordship will kindly see page 23, E2, the Nagaland Retirement from Public Employment Second Amendment Act 2009. So that impugn letter was issued basing upon this, which does not cover the petitioner's late husband. Lordship.
Now, what is the age of retirement as per the 2017 rules?
60 years, as per 2017.
And
60 years.
And that is annexure E.
Annexure E, yes, 60
Now-
years.
Now, which rule has been applied to?
District Court employees rules, Lordship, because he was serving under the, which retirement rule cannot be applied to the petitioner's late husband. He is covered, the petitioner's late husband is covered by the Nagaland District Court employees rules
So
2017.
Which stipulates that it is 60 years.
60 years, 60 years.
But what rules have been now being applied by the impugned letter?
23, page 23, annexure E2. The further amend the Nagaland Retirement from Public Employment Act 1991, be it enacted in the 60th year of the Republic of India as follows. Short title and commencement, so and so, Lordship, it may not be read out. 2. Amendment of Section 3 of the Nagaland Retirement from Public Employment Amendment Act 2007. The existing
So
entry
you
shall.
have been, when did you die? You died in 2022.
Yes, Lordship.
Your husband died in 2022.
22, Lordship.
At that point of time, he did not attain the age of 60.
No. He has not attained. He
And
has,
what
at the
is
time,
What is the age of retirement in terms with the
Retirement
the
Act.
establishment rules?
35 years in service or 20 years, whichever is earlier. 60 years, whichever, 35 years of service or 60 years, whichever is
So
earlier.
on the basis of 30 years of service, 30 years or 35 years of service,
35 years of
it was
service,
held that in 2019 he has retired,
Lordship.
although he worked till 2022.
Yes, Lordship. So by that time when he expired, he was covered by the court employees rules. Lordship, he was retired under this Retirement from Public Employment Act 2009. So the petitioner approached
So-
this.
So therefore, your case you want to bring the case on the ambit of Rafiq Masih?
Lordship, here, the All Nagaland Judicial Ministerial Staff Association approached this honorable court in writ petition number 192K of 2008, 2018, annexure D1, page 18. So,
Okay, madam, the question of granting you a direction or
Yes.
passing a direction at the interim stage would not be proper. Because
After-
this aspect has to be considered.
Lordship,
Will you notice?
my lord will
You
kindly come.
File your affidavits. You file
Lordship,
your
at this
affidavit.
point, notice maybe,
Yeah,
I am only for responding on 1, 2, and 3, Your
But it
Lordship.
is a question of pension, so I think the Nagaland government will take the matter with some anxiety,
Lordship,
urgency.
Your Lordship, instruction has to be sought, Your Lordship.
Yes.
Your Lordship, I am only for responding on 1, 2, and 3, Your Lordship. The other will also be very important, Your Lordship.
Who is 6? You have a
6 is
standing
AG,
counsel of the-
Lordship.
Standing counsel of the accountant general? No,
Council is there, but.
standing counsel of the accountant general, I think you have, no?
Not present, Lordship.
And who is the Gauhati High Court lawyer
Lordship, previously it was AG.
now?
He may be continuing, Lordship. I'm not aware of that. Council of the
We'll take it after some time, after 10-15 minutes.
Lordship.
Just ask somebody to find out who is the Gauhati High Court lawyer. We'll take it
Lordship.
after, because then we
Lordship.
can serve the notice.
Lordship.
And madam, you find out as regards whether Mr. A. Jimomi still is the accountant general's counsel.
For admission, item number 2.
Lordship,
Yes.
Yes, Lordship, I've received the recast affidavit of opposition filed by the government this morning.
Oh,
Yes, Lordship.
you want to file
There's a
a
little
reply?
amendment made in the affidavit in opposition.
Hmm.
Lordship, pleadings are completed here.
Hmm.
So the matter may come up usual course of the hearing.
What are you asking for? Setting aside an order of a 20 1/2021. What is this?
Lordship, that's a cancellation of my mutation.
Cancellation of your
Mutation, Lordship.
mutation.
Yes, madam.
Why? It has been cancelled?
Lordship, DC Dimapur, without following due procedures, has cancelled my mutation without considering the facts and circumstances, Lordship. Therefore, I'm challenging the said order.
You are claiming your right on the basis of a trade license.
No, Lordship.
A right
on the
over the
basis of
land?
an allotment, Lordship.
No, but this has been mentioned as a trade license and an electricity bill. You have an allotment?
Yes, Lordship.
Where is it? In your writ petition? No allotment.
Lordship, allotment was on the basis of order.
What? Oral allotment? Who gives you? When? Allotment given by the DC orally. Better it comes for hearing only. Isn't it? There's a stay.
No.
No stay. What is wrong with the order?
Lordship, back in the year 1975, the STO Civil Dimapur has allotted me 100 into 23 plot of land for establishing my business. So,
Did you get your mutation done then? Hmm? Receipt of the license fee, notice, order dated so and so, trade license, nothing else. What is wrong with this order? And if you are aggrieved, why don't you file a civil suit? You claim that it is your land. And this has been done in the name of some Nitovi A. Whatso. So, why you are not filing a civil suit if you have a right? Because this is a case of oral.
Lordship,
Unless you want this court to have a particular witness box there.
Lordship, DC is the custodian of the document, so he must be having this document. So at a time of rejection or cancellation, this document has to be properly verified. whether
There
it is
cannot be a
valid or not.
document unless you have a document. And if you have a document, better off ask the DC to produce it in a civil suit. But if you don't have, what is wrong with this order? You can't file a writ petition out here. I would have understood there is a document which you have, which have not been considered. And it has been mainly considered on the basis of a trade license or a, what do you call, electricity bill. But electricity bill cannot confer you a right over the land, neither a trade license. Then, what is wrong with this order?
In that case, Lordship, the bill may be given to me to file a civil suit.
What?
Or to,
File a reply,
no, Lordship, to withdraw the case.
withdraw.
Yes, Lordship, Lordship.
You do one thing. I will allow you to withdraw, but keeping your rights open, you go to the civil court. Better off. Huh? Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the respondent.
1 to 3.
1, 2, and 3. And who appears for the private respondents? Anybody?
None of this.
Huh?
None of this.
None has appeared on behalf of the private respondents on call. The instant writ petition has been filed by the petitioner challenging the order dated 21/2021, whereby the petitioner's objection filed to the petition granted in favor of the private respondent, number 8, has been rejected. Full stop. It is the case of the petitioner that the petitioner was granted an oral allotment in the year 1975.
75.
And on the basis thereof, the petitioner has been carrying on the business. Full stop. Be that as it may, from the materials on record, it is the opinion of this court that that for deciding as to whether the petitioner has any right over the land, it would require evidence, examination of evidence, both oral and documentary, which this court under Article 2 to 6 of the Constitution cannot do so. So considering the above, this court dismisses the instant writ petition on the ground of maintainability. Be that as it may, the dismissal of the writ petition would not prejudice the petitioner to avail remedies before the competent court of civil jurisdiction. See?
Item number 3.
May I please, Your Lordship?
Hmm.
I beg your apology, Lordship. I am appearing through VC, Lordship.
Yes, tell me.
Lordship, the matter relates to re-verification of the documents, Lordship. The petitioner herein, they applied for a post of carpenter, cook, and barber, which was issued by the Assam Rifles, Lordship, in the year 2018 and 19. A written test was conducted. They qualified in the written test. Trade test was conducted. They qualified. Your Lordship, final merit list was issued showing the petitioner's domicile to be suspected, Lordship. And thereafter, we submitted a representation before the concerned respondent authorities. That has not been considered. We have filed the representation seeking, praying
You
for.
have submitted a representation on 23/7/2021
Yes, Lordship.
to the respondent authorities, and the
Yes.
respondent authorities have not considered that.
Lordship.
That is your entire case.
Lordship.
Yes? Why are you not considering?
Your Lordship, I am for Deputy Commissioner, number 3, Your Lordship. Your Lordship, the representation was not considered by the Union Central, Your Lordship.
Who?
Union Central, Your Lordship, Ministry of Affairs, Your Lordship.
Why? Where is the union? Union is a party?
Yes, Your Lordship, very much.
Lordship. Respondent number 2, Lordship.
So it has to be considered by the union, the respondent number 2. Who is appearing for respondent number 2? Yes.
ZN annually is representing respondent 1 and 2, but is indisposed.
It's okay. It is only required to be considered. Consider it. Okay. What is it? Anything? You consider it. He wants his representation to be considered. Consider
Lordship,
it.
Lordship, may I pray for it?
As per law. Is there any problem?
Your Lordship, I also have completed my affidavit and like ready for.
You are
dating,
not
Your
going to
Lordship.
consider the representation?
No, Your Lordship, not representation. I am for Deputy Commissioner and the domicile certificate, the permanent certificate has been issued by the Deputy Commissioner, Your Lordship. That is the government
So
made by
did
the
you,
petition.
did you issue any domicile certificate? to
That's
the
why, Your
petition?
Lordship, I received the document, I put it in the affidavit, it's ready for vetting, Your Lordship. and-
Okay, you want to file an affidavit?
Yes, Your Lordship, it's complete, Your Lordship, just 1 week and it will be done,
Okay,
Your Your Lordship. But otherwise, Your Lordship, the respondent no number 1 and 2, Your Lordship, lacks jurisdiction to this present petition because petitioner number 1, Your Lordship, appeared exam in Jorhat, Assam, whereas petitioner number 3 appeared exam in Silchar, Assam, Your Lordship.
And they won the job here.
That is the thing, Your Lordship. So,
Show me the, yes, Mr. Counsel.
Lordship, the advertisement covers the entire northeastern region, Lordship.
Very well. Well, then why didn't you go to the principal seat? We were waiting out there.
Lordship, they applied from the state of Nagaland, Lordship. And the verification which is conducted and has to be done by the deputy commissioner. We are seeking it
Show me the advertisement.
at page 59, Lordship.
59. Let me see. Yes, what is it? You applied for which one? Trade? Rifleman?
Lordship, rifleman, petitioner number 1, carpenter, petitioner number 2, cook, and petitioner number 3 is barber.
And how do you get hold of all the three, applying for 3 different jobs in one writ petition?
Lordship, the advertisement is 1 and the final merit list is 1.
And the lawyer also for the petitioner happens to be 1.
Lordship.
Okay. So yes, how to apply? To apply, yes, let's come to page 59.
To apply, fill up the online application by clicking online. So it nowhere says, advertisement nowhere says that a particular candidate has to be from it.
And what is the domicile thing? Where is it mentioned? Why do you require domicile thing? Your entire basis is on the basis of the domicile.
Yes, Lordship.
Then you are now in the luxury out there at your place and you don't know where the domicile aspect is in the advertisements.
Lordship, it is nowhere mentioned.
Then why you are considering about the concerned about the domicile then?
Because they asked for the domicile, Lordship. The respondents. The respondents, Lordship.
Is it? Show me that.
Yes. At page 69, Lordship, the final result list.
Yes, then
Page 70, serial number 481, petition number 1.
51. Yes.
481, Mukesh Kumar Gupta, he is the petitioner number 1, domicile suspected to be produced.
No, the domicile is suspected, comma, to be produced.
Yes.
Have you produced?
Yes, we produced it.
Then
And thereafter, Lordship, if final result was issued
when?
on 22 October 2020, your Lordship will find at page 84, page 83, Lordship.
Yeah. Not selected.
Not selected. The remark column is absolutely silent. And we do not know why we were not selected, Lordship.
Earlier you were selected.
Yes, Lordship.
So the question is, you have to challenge the non-selection. Have you challenged the non-selection?
Yes, that has been stated by this honorable court by way of an interim order at a motion test itself.
In this writ petition.
Yes, Lordship.
Now how? But that is not your case at all. In your what is your relief sought for? Not consider a representation submitted there and do the needful. Where is the challenge to the select list?
In the cause title is there, Lordship.
Cause title. See the relief. What are we asking for? That your representation should be considered.
Yes, Lordship.
But you are not challenging the select list. If you don't challenge the select list, can you get any relief? No.
In that case, I may be allowed to modify my for filing by
Not
filing an
modify.
item.
You have to withdraw. How can you modify? The entire thing is a different thing. You are asking now that your representation should be considered.
Lordship.
Can a representation be considered when the select list is not been challenged? Tell me.
Lordship.
Not possible.
Lordship.
You withdraw with liberty to file.
Yes, Lordship.
Huh?
Lordship.
The learned counsel heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner who submitted that he may be permitted to withdraw the instant writ petition, taking into account that there is a formal defect in the instant writ petition of not challenging the actions of the respondent authorities in not selecting the petitioners. Taking into account the above, the instant writ petition stands closed on withdrawal. However, the petitioner is given the liberty to refile by selecting by challenging the select list.
Lordship.
Interim orders, if any, stands vacated.
Lordship. Obliged, Lordship.
Item number 4.
Wait, please, Lordship.
What are you challenging?
Lordship, I'm challenging the regularization of the private respondents, Lordship, from 4 to 15, Lordship.
You're
They
challenging
were regularized, Lordship.
petitioner service as work charge so-and-so should not be regularized.
Yes, Lord.
Then to quash and set aside the interim regularization order of the respondent numbers 4 to 15. So 4 to 15 is represented.
No, Lordship, we have served notice by way of.
Service
register
is
post.
complete.
Complete, Lordship.
Service is complete.
Yes, Lordship, it's complete, Lordship.
And has the government filed the affidavit?
Yes, my Lord. Government has filed affidavit, Lordship.
And the respondent 4 to 15 are not.
No, Lordship, no. Lordship. No, Lordship, in the state's affidavit, Lordship, they have pointed out that I was found to be irregular, Lordship. And the regularization was considered on the basis of merit. That is the contention of the state, Lordship. However, there's no record to show those, to substantiate their contention.
But why are you challenging 4 to 15 when
They
you
were
are
junior
only
to me,
one?
Lordship. They were junior to me. All those are junior to me, Lordship.
Huh?
4 to 15 are junior to me, Lordship.
Okay.
Of course, I understand, Lordship. There's only one post required to be regularized, Lordship. If I may be allowed a week's time to file reply to their affidavit in opposition filed by the state, Lordship.
Okay, when did they file?
13 to 2004. 2004.
Last week, Lordship, last week.
13 to 2004.
Certainly. So you want to file a reply?
Lordship, I reply.
Okay, Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, 2 weeks' time for filing a reply against the affidavit in opposition filed by respondent numbers 1, 2, and 3. First, list the matter again on, when do you want it? On 18th of March?
Lordship.
On 18th of March 2024, the petitioner shall file their reply on or before the next date.
Much obliged.
Item number 1.
Lordship, I have been informed that current counsel Ajimum is still the standing counsel of Gauhati High Court, Kohima bench. And
Madam, you are?
Lordship, I'm appearing on behalf of my senior, Mr. A. Jimoni, Lordship. Lordship, I can accept notice. of my
Very well. And who appears for the accountant general?
Lordship, principal
senior?
bench, I don't, principal bench counsel, I'm not aware.
Who appears? Accountant, last time when I appeared out here, somebody appeared for accountant general. Because here the main respondent is the accountant general.
Lordship.
Because they only have to file the affidavit.
Lordship, only that.
Issue notice making it returnable on eleventh of March 2024.
For disposal, Lordship. For disposal, if they could file in between, because
let's see, 11th of March 2024. Full stop. Ms. So-and-so appears on behalf of the respondent numbers 1, 2, 3. Ms. So-and-so appears on behalf of the respondent number 4 and 5.
Lordship, 5, Lordship, for the Kohima bench, Lordship.
It's okay, for 4 also it's the same. 4 and 5, it's one and the same. 4 and 5. As the respondent numbers 1 to 5 are duly represented, extra copies of the petition be served upon them by 21st of February 2024. As regards to respondent number 6, the petitioner is directed to take steps by way of registered as well as usual on or before 21/2/2024. The case of the petitioner herein is that the petitioner's husband was working as the
UDA cum Peshkar.
UDA cum Peshkar in the court of the Principal District and Session Judge, Dimapur, Nagaland. Full stop. Unfortunately, he expired on 9/5/2022. Full stop. It is the specific case of the petitioner that the service conditions of the petitioner's husband was regulated by the Nagaland District Court Employees Service Rules 2017. And as such, in terms with Rule 24 of the said rules, the retirement age of the petitioner's husband would be 60 years. However, by the impugned order dated 18/7/2023,
It's Lordship,
The-
letter, not notification, letter.
okay, by the impugned letter dated 18/7/2023, the office of the respondent number 6 have initiated steps for recovery on the ground of incorrect fixation of the pay as well as on the ground of overstay. Full stop. The respondents, more particularly the respondent number 6, the respondents, more particularly the respondents, are directed to file their affidavit on or before the next date, stating inter alia as to whether bringing on record their stamp and stating inter alia as to whether the husband of the petitioner would be regulated as per the Nagaland District Court Employee Service Rules 2017 or any other rules. This court further directs that the respondent authorities
Obliged, Lordship.
Item number 5.
Please, Lordship. Lordship, the state has filed the affidavit. If I may be allowed a week's time to file reply, Lordship. I have received just 3 days back, Lordship.
What affidavit?
I've given a reply, Lordship.
When did you file? Okay. This is filed on 15th of December. You got the whole
Lordship, I
entire
received a
winter.
copy only last week, Lordship.
Yeah, I could not able to furnish your Lordship, and I could furnish only last week, Lordship.
You were terminated.
Yes, Lordship, I was the minister in service, Lordship.
the learned counsel appearing on behalf of the petitioner seeks for an accommodation of 3 weeks. 3 weeks?
Lordship.
For filing a reply against the affidavit in opposition filed by the respondent numbers 1 to 3. This the matter again on 22nd of March 2024. In the meantime, the petitioner would be at liberty to file the reply.
Lordship, much obliged.
Lordship, Lordship.
Item number 6 to 16.
Yes, why so many matters?
May it please, my Lord, Lordship, this is a
Please,
bit,
Lordship, your Lordship, here I am yet to file my additional affidavit. It is ready, your Lordship, only waiting is awaited. So I just pray for the 3 days time, your Lordship.
Okay, all the respondents are duly represented.
Lordship, Lordship.
So everybody has filed their affidavits.
Yeah, Lordship, they are to
My lord, in
file-
item number 8, WBC 191, my lord, I'll be filing it during the course of the day.
Okay. Okay. Then we fix it. What are we doing it challenging here?
Lordship, we are challenging the appointment orders of the private respondents who were appointed through backdoor.
This matter came up before me earlier or something similar to that.
There are so many similar cases, Lordship.
Oh, that last time when you were moving that, no?
Lordship, Lordship. That is,
Yeah. Oh, yes, yes. I
that is again
remember.
another one.
No, this matter came up before me. I remember 29/11/2022. Chalo.
In that matter, since the
So. we
parties have
fix-
exchanged
we-
affidavits,
We do
Lordship.
one thing. We admit these matters,
Lordship,
fix it for hearing on a particular date.
Lordship.
In the meantime, all pleadings be completed. I think better off.
Lordship, Lordship.
Upon hearing the learned counsels appearing on behalf of the parties, this court finds it. This court is of the opinion that the instant batch of writ petitions requires to be heard or requires to be admitted. Accordingly, issue rule. Full stop. Taking into account that all the respondents are duly represented and have already received their copies of the writ petition, there is no necessity for further service of the writ petitions upon the counsels representing the respondents. Full stop. List the matter for hearing on when?
Next week, Lordship.
What?
In usual course, Lordship, in usual course, registry, let the registry.
No, everybody has some hope when they come to the court to get something. We'll have it on 18th of March.
Lordship.
18th of March for hearing. Full stop. In the meantime, if any of the parties to the instant proceeding wishes to file their pleadings, their pleadings should be filed and completed on or before 13th of March.
Lordship.
Oh, Lordship, Lordship.
Item number 17.
Please, Lordship.
Yes.
Lordship, the CTC is yet to file their affidavit.
It's okay. Who is appearing for the respondents?
I'm for the state.
State. Have you passed the award?
My
Have
lord,
you passed the award?
No, my lord,
Why?
because here the Ben respondent, the respond number 1,
Who is the respondent number 1?
the CTC, the Union of India.
This acquisition is done under what provision? Acquisition is done under what provision? Who is acquiring the land?
This is the Union of India, the railway.
No,
railway department.
the railways do not acquire lands. Acquiring of land is done by the district by the district administration, the collector. This is acquired under what provision? Mr. Counsel for the petitioner. This is acquired under what provision?
Under Nagaland Land Acquisition and Acquisition. Act
Fantastic. So if it is
1967.
by the Nagaland Land Acquisition and Requisition Act, then under such circumstance, it has to be by the collector. This is under the 65 Act.
Yes, yes.
Then it will be by the collector. So you will be
My lord,
knowing it.
Compensation should be paid by the railway, my lord.
They are the requiring
They are
authority.
claiming for the compensation, land compensation.
Mr. Counsel, they are the requiring authority. You are the acquiring authority. Have you passed the award? I'm asking you a very simple question. Have you passed the award? If you have passed the award, then if you have not passed the award, you take into consideration as per the Right to Fair Compensation Act. But if it is not, because what is he asking for? He is asking that he should be given as per the Right to Fair Compensation. If you have not passed the award, you are bound to do that. There's no, the only problem is that in you have a problem out there that in Nagaland, the right to fair compensation has not been implemented.
No, that regarding the compensation, my lord. Compensation is to be paid by the,
Mr. Counsel,
yes,
you are going to acquire
yes,
on behalf of the railways.
yes, my lord.
And the railways have to pay the money.
Yes.
The railways will pay. We'll see when they pay or not.
My
But
lord,
as of now, have you passed the award? That is the question.
we have not passed the award, but we have already processed their case to the railway. We have already forwarded to the railway, but the railway are yet to pay the compensation, my lord. We have verified the case of the petitioner and we have already forwarded.
Show me.
My lord, in the affidavit, my lord, I filed my affidavit. Your lordship, may kindly see my affidavit.
This is by 2, 3, 4, and 8.
Yes, my lord, in para 5. Para 5.
And who is paying for the railways?
No one is paying, my lord.
And the Union of India has to appear. For railways, you don't have a Union of India Council? Mr. Gauhati, where is he? He is the council.
Yes, my lord.
Then
Gauhati and.
he has to appear. He cannot say that he can't appear because nowadays the railways don't have a different council. The union has to be represented. He's not around. Not here. I don't see him here. I also know. But otherwise,
What's up? I think he's in court too.
we'll take it up after some time. Ask him to come. Because then ask him to file his affidavit, what is there stand. Then I think the matter can be proceeded with. We'll take it after some time, ask him to come.
Item number 18.
Yeah, please, Your Lordship.
Hmm.
Lordship, I pray that this matter may come up after 2 weeks, Lordship.
Why?
That's why I need to see some clarification of Lordship regarding the roster is maintained by the concerned authority and the RDF filed by the petitioner, Lordship.
You have an office memorandum
Lordship,
for compassionate appointment.
Lordship, we do.
So, as the petitioner must have filed an application, and as per your office memorandum, it is put in the particular list.
Lordship, so,
Serial number.
Lordship, yes.
What is the serial number of the petitioner?
So, Lordship, the RTI filed by the petitioner, Lordship, they have this roster list, Lordship, and then the roster that I've received in the previous week, there's a contradiction, Lordship, so I need some clarification, Lordship.
Okay, now Wednesday we get the list.
Lordship.
Wednesday we get the number, what is there in the list. He will be in a particular list. If he has filed, as per your thing, as per your own office memorandum, whenever a person files, he is put in a list.
Lordship.
And it goes on. You give a 5% of yours, 5% of the grade 3 or grade 4 services are put in the compassionate appointment. So you appoint it on the basis thereof. So whenever first come, first basis. So what is there in the list? You just come up with that instruction. That's all.
Lordship.
He is only asking that to be considered. If you tell me that yes, he is already in the list, his consideration is done, what remains in this petition? We'll have it on Thursday. This is the matter on Thursday.
Lordship.
On which date the learned counsel appearing on behalf of the state
Lordship.
shall apprise this court as to whether the petitioner's application for compassionate appointment has been duly considered, has been taken into consideration.
Obliged, Lordship.
Item number 19.
Yes, madam.
Mr. Lordship. Can you grant me 2 weeks time, Lordship, to file my affidavit?
You have not filed your affidavit.
I'm yet to receive my instructions, Lordship.
We impose a cost. No, because you have not filed on 4/9/2023, 26/9/2023, 30/10/2023, 28/11/2023.
Lordship.
And she has to come every time. Where do you stay? Nearby?
No, Your Lordship, no.
You pay every day her expenses. 10,000 per day, 40,000? 40,000? 30?
No, Lordship.
No, then
Lordship.
you have been, every time you have been taking time. She has to come all the way because of that. Doesn't looks nice. In the principal seat, I every day put the cost. See, every time you are asking for time.
Last chance, Lordship.
Last chance.
Lordship.
Subject to cost. Next time cost.
Lordship.
Or this court shall proceed. The record reveals that the petitioner has, the respondents have not filed their affidavit in spite of seeking adjournments, seeking time from this court on 4/9/2023, 26/9/2023, 30/10/2023, and 28/11/2023. Today, Ms. Swenso, the learned counsel appearing on behalf of the respondent, seeks for further accommodation for the purpose of filing the affidavit. First, this is a case where the petitioner herein is seeking an appointment, and a delay in filing the affidavit is affecting the rights of the petitioner to avail remedies before this court. Considering the above, this court, in the interest of justice, grants a final opportunity to the petition respondents to file their affidavit. First, failing which, this court shall impose exemplary cost on the next date. First, failing which, this court shall take up the petition for final disposal on the basis of the materials available on record. First, list the matter again on 11th of March 2024.
Item number 20.
In this matter, I have instructions to give for respondent number 1 and 2. On the last, I received instructions in the month of January this year. And we have 3 weeks time to find my affidavit.
2 weeks time?
Yes.
For whom?
For the respondent number 1 and 2.
What is this matter about?
I'm challenging the seniority list, the grade of general manager.
Of Nagaland Industrial Development
Yes,
Corporation. Mr. Iralu, the learned counsel appearing on behalf of the respondent number 1 and 2, seeks for a accommodation for filing the affidavit on behalf of the said respondents. The record reveals that the respondent number 3 has already filed the affidavit in opposition, and the petitioner had also filed the affidavit in reply. Be that as it may, a final opportunity is being granted to the petition, respondent number 1 and 2 to file their affidavit in opposition. Which list the matter again on 18th of March 2024. So the affidavit be filed, the respondent shall file the affidavit in opposition. The respondent number 1 and 2 shall file the affidavit in opposition on or before 8th of March 2023, 11th of March 2024. So the petitioner, if so advised, would be at liberty to file the reply on or before the next date. Interim order passed earlier shall continue till the next date.
Item number 21.
Lordship made, this matter has been settled outside the court. Amicable settlement has been met between the parties. So I would like to place the agreement between the parties. And then in lieu of that, I may be allowed to withdraw this case as the matter has been settled.
The learned counsel appearing on behalf of the petitioner submits that he may be permitted to withdraw the instant petition, taking into account that the matter has been amicably settled. In that view of the matter, the instant petition stands closed on withdrawal. Interim order, if any, stands vacated. I stands closed. Stands closed in view of the withdrawal of the petition.
Item number 22.
Please, Your Lordship. Lordship, I'm appearing for respondent number 4, the Nagaland Lokayukta. I'm led by my senior, Mr. T.B. Jamer. He has some personal difficulties today, therefore, I pray that the matter may be listed for admission hearing on Thursday, the 22nd.
At the request of the learned counsel for the respondent number
4.
4. At the request of the learned counsel who submits on behalf of the respondent number 4. At the request of the learned counsel for the respondent number 4, matter stands adjourned to be listed on Thursday.
Item number 23.
Yes. Yes, you're challenging something.
Your Lordship,
This matter, I filed my affidavit, but I'm yet to serve a copy. Just now only I've served a copy. So if
You have filed the affidavit on 29th of November.
59, yes, Your Lordship. But I could not serve a copy to the petitioner, Your Lordship. I'm sorry, Your Lordship.
How was it allowed to be filed without serving a copy?
I've undertaken to serve a copy, Your Lordship.
Within
My-
1 week.
Your Lordship.
Ms. So the learned counsel appearing on behalf of the respondent numbers 1, 2, 3, and 4 submitted that the affidavit though the affidavit in opposition was filed on 29/11/2023, but the copy of the said affidavit in opposition has been served to Mr. Muajami so and so on today. Have you received it?
now, yes.
You want to file a reply?
I would like to go for
Mr. So-and-so, the learned counsel for appearing on behalf of the petitioner submits that he would like to take instruction from his client as to whether the petitioner would like to file a reply to the same. Taking into account the above, this the matter again on 15th of March 2024. In the meantime, the petitioner if so advised, would be at liberty to file the reply.
Item number 24.
Please, your lordship. This matter may be listed on Thursday as a fixed item. Today in the second half, I may have to proceed to Mokokchung for a meeting. My learned friend TB Jamir also is going for the same. Mr. Takamasa is also going. Thursday as a fixed item, lordship.
What are you challenging wherever the petitioner has been released from service?
There is some
Without
discrepancy
following
with
it.
regard to
This
the,
is compulsory retirement.
no, it's not like that, but then by misinterpreting the provisions of the Nagaland Retirement from Public Employment Act, he was made to retire before completion of 35 years. And the dispute is with regard to the counting on which date he length of service should be counted. Government has already issued an order making it from a particular date. That is, in view of so many discrepancies, in order to avoid, government has issued a notification fixing a particular date for counting seniority, counting the length of service. That was in 1989. And then if we are to go by that, the petitioner is due for retirement on 30th of November 2024, this year. But, and all along in the government records, that date was used for the date of retirement, even in the seniority list, even in the KMS, everything is shown.
Okay, we'll hear it on Thursday because this matter requires urgent disposal. No?
Lordship, yes.
This is a matter on, at the request of Mr. C.T. Jami, the learned senior counsel. Matter stands adjourned to be listed again on Thursday. An attempt shall
As
be
a
made
fixed
to
item.
dispose of the matter on the day.
Lordship.
Item number 25 to 36.
May it please, my lord, lordship, in item number 190, respondent number 5, 8, 10, and 12. Here in our note, only this 4 respondents have not,
All these are without advertisement, appointments,
lordship.
and had the respond number 5 and all these things, they have filed the replies.
Chief, I'm presenting this 5, 8, 10, 12. Affidavit is under preparation.
So you file it next
We
week?
will file after a week.
Okay, week is today, Monday, next week, Monday, we'll have it on Thursday,
Lordship,
Tuesday.
I'm for respondent 1 to 4 for the state. We are yet to receive instructions, Your Lordship.
Okay, file it on next, because
3 weeks may be
it's a
given
case
the-
of a person being appointed without advertisement. Now, only thing you need to show before, I don't require anything else. It's a public service. Is it required as per the materials on record as to whether an advertisement is required? And if not, and if it is required, there was an advertisement. That means, well, affidavit will help you. Isn't it? You have already received your instruction. So you want to file it by 11th, file it by days 19, by 26. We will have it on 27. In fact, your instruction will help me. You have the instruction, please?
We have not received any instructions as such.
You said you have received the instruction.
No. For the state, we have not received any instructions.
Get your instructions.
So
By
2 weeks at least, Your Lordship.
26th.
26th.
Get your instruction. Now we'll hold it that there is no requirement of a, this has been held without advertisement. If you want to file your affidavit, file your affidavit. Taking into account the matter in its entirety, this court grants a final opportunity to the respondents to file their affidavits by 26th of February 2024. To list the matter again on 29th of February 2024.
Obliged, lordship.
Item number 37.
Please, Your Lordship. Your Lordship, 3 weeks may be granted to me, Your Lordship.
Wait. Here there is no order has been passed. Oh, this is Jagjit Singh. Equal pay. Yes. You want to file affidavit?
Yes, Your Lordship.
So and so the learned counsel appearing on behalf of the respondent numbers.
For the all, for the state
All the
respondents. All the
respondents,
state
all the
respondents.
respondents, 6 for an accommodation for filing the affidavit. To list the matter again on 22nd of March. In the meantime, the affidavit will be filed by the state respondents on or before 18th of March.
Item number 38.
Sure, Mr. Lordship. Lordship, I give the receipt instruction.
Same order. Same order. 22nd March, file your affidavit by 18th March.
Item number 39.
Lordship, in item number 6 to 16, Lordship, it has been fixed on 18th March, but I beg your pardon that on 18th there is some prior engagement, so whether it can be on 19th.
Okay.
6,
Inform all the councils.
Lordship, that we will inform.
That is your responsibility.
Lordship, I will inform Lordship.
19th.
19th. Obliged, Lordship.
Yes, what is this, Mr. Jagmeet? For vacating? Yes, what is it? Let's see.
There, please, Your
What is the writ petition file? Writ petition challenging what?
Lordship,
Everything is interim in nature, Lordship. The writ petition was filed challenging the interim direction passed by the Principal Judge Family Court, where the principal judge has a recent order. It is with regard to the child custody of 4 years old, and I'm for a mother. Now, relationship became strained in the month of September last year.
Who is Mr. Jameen, who is the petitioner?
Petition.
the petitioner is the husband.
Writ
I'm
petitioner is
You are the
the
petitioner?
father.
Yes, tell me, why are you approaching this court, challenging that order?
Your Lordship, the main ground is that the council for the applicant, that is the wife, and Dimapur is the nephew of the sitting judge, Your Lordship. And on that day, when on 19th, when the child was produced, even the court had interaction with the child, then without passing any orders, he directed that the child be handed over to the wife. No order was passed, only orally direction was given. Now, agreed by that, the petitioner had to approach this honorable court on 22nd.
She's a relative, she's a relative, the principal judge?
Yes, Your Lordship. The principal judge, her own nephew, is one of the counsels, the principal counsel in the case. That is
We are
all.
denying that, Lordship, because he was not the counsel. The one which we are saying that he is the counsel. Lordship will know from the records.
No, where's the principal judge?
Yes.
Related to one of the parties?
No.
That is what
The
he
counsel. The counsel is one of the relatives of the principal judge. That is
Counsel.
the allegation they are making.
Now, what is the allegation? Let's see.
But the engaged counsel was different, not the one which they are saying.
Now, whether it is the engaged counsel or the principal judge?
The engaged counsel and the principal judge, they are related, Your Lordship.
Or not the parties?
Not the parties.
So,
Your Lordship, that was, Your Lordship will see the order here, Your Lordship, in one, I have had an affidavit.
where's the order? Where's the impugned order?
The impugned order is in the IA, Your Lordship.
You are challenging an impugned order? No, you are not challenging that order. Where's that order? This one, 5512. Which order is this? Where is the order?
Lordship, improved order, Lordship, will find in the IA at page 24. IA, page 24. And operative portion in the finding, Lordship, will find at page 53.
Page
53. The last paragraph. It starts from last paragraph. Page 53 of the IA, third argument, the last paragraph, Lordship. The operative portion starts from.
What is the age of the child?
4 years.
And,
He is with the
and it
father.
has been, custody has been given to whom?
Your Lordship,
Custody has been given to whom?
custody as per this order was to be given to the mother, Your Lordship.
No, no, has been given to him, mother.
By the impugned order, by the order, Your Lordship. But on that day, on 19th, the child, the case is like this, Your Lordship. There has been no separation at all, but because of concern for in the family, the husband couldn't stay at home, so he left. The eldest daughter, she wanted to, she was desperately trying to go along with the father. So they went and stayed with at the parents' residence, the husband's parents' residence in Kohima. Now, in between that, since it was a valid marriage by a church, the pastor and the witness who were there, they were making some, the petitioner and his family, and along with the family of the wife. At one meeting, they came to the conclusion that some mediation should be done by the pastor and all. And the pastor and the witness at the wedding, they were making their endeavors. Then in the meantime, this petition was filed, Your Lordship, by the wife for custody of the child. So we contested the custody
Tell
petition.
me one thing.
Yes.
I mean, let us make it very simple. The custody has been given to the biological mother?
Yes, and I am the biological father.
It's
Yes,
okay.
Your Lordship.
No. You are the biological father.
Yes. Lord.
It has been given to the mother, and in the meantime, that was to be given prior to the Christmas to the mother.
Yes.
And the mother would return the child on 27th. After New Year's, again you have to give it to the father.
No,
the
as
mother.
per the order, yes.
Yes,
As per the order, but this order was not there available, made available to us. The only direction was that on 19th, the order will be passed subsequently. You immediately hand over the daughter to the mother. That was the only oral direction given
So
by the court.
are you agreeable with the directions in page 56? Page 56 directions which are there seems to be very reasonable. Why should this court exercise 227?
Your Lordship, since after the interim order passed in this petition only that this order was passed, Your Lordship.
Anyways,
This
but
order
as
was
of now,
So-
this is the order. If this is the order, are you agree with this order?
Your
We are not
Lordship,
challenging this
presently-
order. This order seems to be very reasonable. It is in terms with the judgment of the Supreme
Now,
Court.
Your Lordship, now the child has joined the school. I am already sending her to the school here in Kohima.
And
So
she and the
now-
mother stays where?
Mother stays in Dimapur. Dimapur, Your Lordship. Dimapur.
Dimapur.
Yes, the mother.
Dimapur has also good school, no?
Even in Dimapur also, the child has been admitted in the Naki school.
No, that
And
was
the
that
academic
was-
session will start from.
No, but
first week
what
of
is
April.
wrong with the order at
That
page
was-
56?
Year prior, Your Lordship.
I would have understood that the
Yes.
judge is related to any of the parties, it's okay, but the lawyer, it's okay.
That is also not correct, Lordship.
It plays.
That is also not correct. Because the engaged counsel was.
And if you are agree with this order at page 56, you can very well file appeal, a revision,
Yes.
whatever may be.
There is
But why
alternative
should this
remedy.
court exercise 226 more particularly,
Lordship.
where the Supreme Court has made it very clear that against an order passed by this court cannot sit under 226, a writ cannot be issued against this. This court can very well exercise jurisdiction under 227.
227 it is.
But this is not under 227, this is under 226.
They are seeking for a writ of certiorari. There is no public element here.
No, where? How can this
It is a
court issue a
private
writ of
individual.
certiorari? This court can't.
Writ doesn't lie, Lordship. In any case.
Because there are so many judgments. If you are aggrieved with these directions out there, there is an appellate forum against this order. Finally, there is an appeal. Why should this court at all exist? And the allegation, yes, I heard you only on the basis that when you said that I was under confusion or couldn't understand to the effect that as to whether it was the relative who were the parties of the judge. No. So it is the council. So it is a different thing that the council should not have done that. But that does not make this order bad because the order seems to be very reasonable.
Your Lordship, after this petition was filed, only this order came out. After
Now,
this,
but
this-
as of now,
Your
but as
Lordship,
of now, this is the order.
Your Lordship, then give me some time.
For what?
Your Lordship, let me.
Have you complied with this order or not?
Your
Have you
Lordship,
complied with this order or
In the
not?
meantime, interim order is still existing in this petition.
I'm vacating
Yes.
it right now. Right
Your
now, I'm
Lordship,
vacating. I can give you time till tomorrow
Since it
morning.
has to do it, it has to do with,
Tomorrow morning, Mr. Counsel, tomorrow morning.
Your Lordship, allow me to make my submission and then if your Lordship is
Tomorrow.
not agreeable, then it is.
No,
not
no, you
required.
you want time tomorrow. This type of, when this is the order out there, there is no question of, first of all, 226 does not arise. 227, yes, this court may think about. But why should do this court taking into account what has been mentioned out here? What is said prior to this vacation, the Christmas vacation, it will be with you. Then after that, New Year's vacation with the father. And then again on 4/1, it will be given to the mother. And the custody of the minor child shall be divided between the petitioner here during the school vacation. The respondent shall have the right of visitation of so and so. And the respondents and his family are allowed to take the child for day-to-day outing with prior consultation, information with the petitioner. However, such outing here. In fact, you may very well file an application before that court saying that, look here, then these 4, 5, and 6 needs to be more made it clear. Because of the thing that certain things, it will require further looking into these things. Because if you say visitation rights will have, you see the respondent and the family shall have rights of visitation. When? These things are required to be.
Your Lordship, the problem is since this custody consideration.
How can you take away the child? That to a girl, it's a girl child.
The child.
A girl child from the mother.
Your Lordship, the child is not willing to stay with the mother, Your Lordship. The child is, and her psychology is, her welfare is more important than.
Your client must have put something out there. That must be the reason why the mother, it's not going. Why will the child won't like the mother? That I would have understood 11-year, 12-year child.
Your
will
Lordship,
not
I have
like.
made specific statements in my.
A statement made by you.
Your Lordship,
Are
on
you
that
saying
day.
that this court is going to consider
Not
that
before,
statement?
Your Lordship, before the family court, I have contested the issue that these are the facts. This is the main fact. Without even hearing without even the learned judge refused
Mr.
to
Counsel,
hear me out.
Mr.
And this
Counsel,
order has been passed.
what is the consideration out here is very simple. One has to look into the welfare of the child.
Yes, Your
Nothing
Lordship.
more than that.
Yes, Your Lordship.
This court will be only considered about the welfare of the child.
Yes, Your Lordship.
Now, if it is the welfare of the child, if these are things where we should have, then we have to convert it into 227. But 227, why should this on the basis of this order at page 56? This court can very well look into in an appellate forum. Kindly appreciate this. If I have to go, this court can 227 or 226 doesn't lie, but 227 will be only on the question of something which is grossly improper.
Yes, Your Lordship.
And if it is grossly improper, that will also have very limited jurisdiction. And even
Your
whereas
Lordship, that
an
is-
appellate
that is
jurisdiction
undisputed.
would be much more, or a divisional jurisdiction will be much more. You
Yeah,
can very
okay.
well file a CRP also. I don't know whether against this order an appeal normally lies or against this is an order under section what? This is under 30?
Yes, Your Lordship.
There's a divorce proceedings.
No, not divorce proceedings.
This is under the
Yes.
Words Act,
Yes,
section 8.
yes.
And against the Words Act, there is an appeal lies. Appeal lies, Mr. Jamil.
Section 47 is very clear. Lord.
An appeal lies.
Guardians and Wards Act.
Huh?
Guardians and Wards Act,
Ah.
section 47 is very clear.
What does it say?
It lies to the High Court.
No, why I'm saying, Mr. Counsel, if you don't file the appeal, it is the jurisdiction of this court is very limited. I do one thing.
This is for appointing or declaring or refusing to appoint or declare a guardian. Your Lordship.
Understood.
Here in this-
We do one
yes.
thing. I do one thing. Wait. Let me fix it on next Monday.
Your Lordship.
In the meantime, without prejudice to these proceedings, I give you the liberty to file an appeal.
Your Lordship.
Okay? You file an appeal. Then this court can very well look into that. You see, 1, 2, 3, and 3, there is no question of looking into. Only 5 and 6, the vegetation rights may be made a bit better. What do you say?
Lordship
But
has
the custody has to be with the mother. There's no quarrel with that. It has to be with the mother because mother is the biological mother. I don't understood anything else. And if the mother is in a position to, and the mother can very well also get the maintenance from the father. You have to pay because he's the child.
The
There's
child
no
is
way
also
away.
admitted in a school in Dimapur
Then-
and the academic
Lordship,
session
my-
will start from April.
April, then nothing.
The class has started in this case. The child is already attending the school, Your Lordship.
It's okay. It's too cold in the
all
weather.
nothing
For
but
that.
Lordship.
Mr. Counsel, it is a 4-year-old child. Remember, we are not much into this academics. Let's not. Till 6 years, you have time. Class 1, let her get into class
It is
1.
not always that the mother
Okay.
is the only one who is.
List the
capable of-
matter again on Monday. The hearing remains
Interim
inconclusive.
custody, Lordship.
List the matter on Monday. That is on 26/2/2024. Pusto.
Instead of
Taking into account section
47.
47 of the Guardians and Words Act so and so, the petitioner is given the liberty to file an appeal without prejudice to the instant proceedings.
And
Lordship,
till then, the interim may continue, Your Lordship. Till then,
No,
the
Lordship.
interim may continue.
No, Lordship.
Don't worry, this court has taken
Yes.
it up, no, this is.
Without enclosing the copy of the impugned judgment, just a statement was made in the writ petition and perusal of the contents of paragraph 9 and 10 of the writ petition. This interim order has been passed. Liberty has been given to approach this honorable court for modification and vacation of the interim order. It is an ex parte order. Against that we have come, Lordship. Instead of complying with the direction passed by this honorable court, the present writ petition has
No,
been filed.
I have given him the
Yes,
liberty
yes,
of the,
yes,
I'm
yes.
not passing any interim, extending
Yes,
anything, nothing doing. You do whatever you would like, but the
But
thing,
in
because
view of the-
Mr. Counsel, I make it very clear.
Your
I'm
Lordship.
going to have it on 26. Your client is losing the custody to him. Only thing is, I may touch on the visitation rights.
The direction given by the principal judge has been suspended by this honorable court, Lordship, on 22nd.
Is it until further orders?
Until further orders only, Your Lordship.
Yes.
So, Your Lordship. since
Instead of complying with the
on Monday-
direction of the family
Then-
court,
You see,
Monday to
they have
no,
approached this honorable court.
Mr. Jami, I'm taking up the matter on 26th
Yes,
for
Lordship.
final disposal. Don't worry,
Lordship.
I'm taking it over there. I'm only giving him the liberty for filing an appeal. And on that, but you file your appeal before that.
Your Lordship.
If you don't file, then it's okay.
Other matters may be different, Lordship.
Item number 17.
May I please start? What's my apologies, but the CTC has already left. He said he cited some personal emergency. What's I advised him about the matter? What's if the matter may be listed tomorrow again? Expedited. Yes.
17 to CJC's name
Yes.
is there, but he has not appeared.
What's initially, Ma'am Nuksindila, as she was appearing, but since her.
Then I'll do one thing. I will send it to the railway ministry. Issue a direction to the railway ministry to appoint a council. That is a better thing. The matter upon being taken up. The matter upon being taken up. There is no representation on behalf of the Ministry of Railways. This court had duly taken note of the affidavit filed by the respondent number 2, 3, 4, and 8, wherein it has been mentioned that the railway ministry, the respondents, numbers 1, 5, and 6, 1, 5, 6, and 7 have not taken steps for which the petitioners have not been, petitioners cannot be compensated. So, taking into account the above, this court directs the respondent number 5, that is the General Manager, Northeast Frontier Railway, Maligaon, to appoint a council to take appropriate steps so that on the next date so fixed, the said railway authorities are duly represented, failing which this court shall presume that the respondent authorities, that the respondent numbers 1, 5, 6, and 7 have nothing to say, have nothing to oppose to the prayer made by the petitioner. This is the matter again on 18th of March 2024. The petitioner is given the liberty of serving a copy of this order to the respondent number 5 for due compliance.
Much of it.
For hearing item number 40.
With this lordship. Petitioner. For this honorable court with a limited prayer for direction lordship for the purpose of pensioner benefits lordship to regularize my husband's service lordship. Only for the purpose of pensioner benefits. I've served for the last 18 years. My husband's passed away on the 11th of February 2019. Slightly after the only contention is that there's no central post at that relevant point of time. There was no central post at that relevant point of time. That was the only contention raised by the state respondents in the affidavit.
So, has the petitioner's husband had expired?
Lordship, yes, in the year 2019, Lordship.
And how many years? 18 years.
18 years. Lordship, I was
Now,
shot by
if it is
7 days.
18 years, would the person be entitled to be brought within the cadre of the state?
Lordship, the minimum is 10 years, Lordship. Minimum service is 10 years, Lordship.
As per?
To pay the pension, Lordship, as per the
No, no,
CCS
no, no,
pension.
no, no. Pension is different. Once a person has 10 years of service
Lordship.
in the cadre,
Lordship.
then he will get. That
Yes,
is one aspect, another aspect. I will not say. But with 17 years as a contractual or what sort
On
of service?
provisional basis.
On provisional basis, can he be brought within the service of the cadre?
Lordship,
Let us assume that he is alive.
Lordship.
As of now, whether he will be entitled to, in taking into account Uma Devi. Very difficult. Because this, you are asking this court to exercise jurisdiction under Article 2 to 6 of the Constitution
Lordship.
for a direction upon the respondents to create a job, create a post for him, and give him or regularize him, that too posthumously.
Lordship.
How is it possible?
Lordship, what has happened, Lordship, while pending this writ petition, the department, Lordship, more particularly the PWD Lordship, they've come up with a decision, Lordship, for those employees who are appointed on provisional basis to be treated as regular employees, Lordship. And that decision was taken only after the writ petition was filed, Lordship. Lordship, may allow me to serve a copy of the notification, Lordship. This decision was taken in the year 2022, Lordship. 30th of March 2022, Lordship. This is issued by the Office of the Executive Engineer-in-Chief, Lordship. May I read it, Lordship? In pursuance to the government letter number so dated 14th of March 22, with regard to the appointment of grade 3 and grade 4 categories of employees under NPWD on provisional basis, it is hereby intimated that such appointments made against regular and sanctioned vacancies under the Works and Housing Department.
Against sanctioned and regular vacancy. How
Yes,
do you
sir.
bring this? And this is as per MRSR judgment.
Lordship.
This is MRSR judgment. There was a judgment, no? Yeah, somewhere here. Ah, this one. This, as per this judgment too, you can't. Having heard the learned stand, it is required to be noted that the deceased and died during his lifetime, he never claimed any regularization. That their prisoner wife claimed regularization at the time of this, it was not a regularization. Also, I heard the improved judgment of the High Court is unsustainable. So, you are covered by the judgment of the Supreme Court.
Lordship.
Against. And the present writ petition has been filed by the petitioner seeking a direction from the court to the effect that the petitioner's husband's service as machine on provisional basis under the establishment of the executive engineer, PWD, National Highways, Division number 1, Kohima, division should be regularized. The facts involved in the instant proceedings is that the husband of the petitioner was appointed on provisional basis by the engineer-in-chief NPWD, Nagaland, by an office order dated 19/2/2001. It has been averred that the husband of the petitioner was receiving his pay as per the pay scale. However, unfortunately, on 11/2/2019, the husband of the petitioner expired, leaving the petitioner and minor children. It is under such circumstances the petitioner filed a writ petition before the court, submitted a representation on 18/3/2019 to the Engineer-in-Chief NPWD Nagaland, Kohima, with a prayer for service regularization for the limited purpose of family pension. The entire basis of the petitioner's case was on the directions passed by the division bench of this court on the basis of the directions passed by this court in WPC number 196K/2014, dated 25/8/2015. This court, upon hearing the learned counsels and also taking into account a recent judgment of the Supreme Court, in the case of State of Nagaland versus Nisevi Achumi, reported in 2022 SCC Online SC 818, is of the opinion that the petitioner is not entitled to the relief so claimed for. The Supreme Court was dealing with an identical situation, and thereupon observed that the directions so passed by this court to regularize the services of a deceased employee one day prior to his death was a grave error. It was also taken note of by the Supreme Court in the said judgment that the husband of the petitioner did not apply for regularization during his lifetime. And it is only after the death of the husband, the wife applied for regularization for pensionary benefits, which could not have been permitted. Paragraph number 6, 7, and 8 of the said judgment, 7 and 8 of the judgment, 7 and 8 of the said judgment, being relevant, is quoted herein below.
sorry for the indulgence, Lordship, if I may, Lordship, with regard to Nishve's case, Lordship. There are three counts on which Nishve's case was considered, Lordship. Lordship has rightly observed that the petitioner, during his service lifetime, didn't approach the department. And also there was a delay of 12 years, Lordship. Here in my case, Lordship, I have approached the department, Lordship, within a period of 2 months, Lordship. There was no delay on my part, Lordship. And as far as Nishve's case is concerned, Lordship, there was no representation by the opposite parties, Lordship. It was judgment in silent, Lordship. No parties were represented, Lordship. Therefore, my respectful submission is that Nishve's case cannot be used as a precedent, Lordship, that
7 and 8 is quoted here. Apart from the above, this court have also duly taken note of the submission of the learned counsel for the petitioner that the judgment in the case of Nisvi Achumi Supra cannot be made applicable, taking into account that the wife had approached the authorities after 12 years from the date of the death of her husband, which is different in the instant case in as much as the petitioner herein had approached 2 months after the death of the husband. Be that as it may, it is the opinion of this court that if the petitioner, if the husband of the petitioner was not entitled to regularization, during his lifetime, the question of issuance of a direction to the authorities for granting regularization posthumously does not arise. Considering the above, this court finds no merit in the instant writ petition for which the writ petition stands dismissed.
Item number 41.
Please, Your Lordship, my senior has some personal difficulties, so I need this matter may be listed after 2 weeks.
Termination.
Yes, Your Lordship.
What are you asking for?
Question my termination order, Your Lordship.
Why you have been terminated? Why you have been terminated?
Your Lordship, if Your Lordship, I can that they've been in opposition of the government. They have stated that we have appeared examination to an interview, and I was in the waiting list. Only after filing of the petition, after filing by the affidavit in opposition by the government, it has come to our knowledge that I was in a waiting list. So I'm not eligible for appointment. That was the stand taken by the government. Otherwise, without no
So
notice.
let's see your termination order, and it's a D.
15, Your Lordship. Page 15 of the writ petition.
Whereas the above template was appointed without following the due procedure for appointment. Now the government has taken a decision for service. So he was appointed on 1/9/2017.
Yes, Lordship.
And he was terminated on 8/11/2019.
Yes, Lordship.
Now, let us see what is the affidavit says.
Paragraph 3 of 5 of the government's affidavits. That's affidavit. Paragraph 5.
3. You are number 8, one post.
But that came to our knowledge only after filing of this writ petition, Your Lordship. So I wasn't afforded an opportunity to defend myself, Your Lordship.
No, no, no.
Nothing was done straight away. Termination order was issued against me, Your Lordship. In the present case.
Your Lordship, they have annexed that list also, Your Lordship. It's there in the writ petition, the list they have appeared. They say that they have appeared exam, they are entitled as per the thing.
Where is there in the petition?
Writ petition also they have enclosed that list, that waiting list, Your Lordship. But instead of mentioning the waiting list, they say that as per that result, they should be getting. I mean, their service should not be terminated.
What is the name
That
of the
their
petitioner?
Ilu
Ilu
Chawang.
Sawang. Waiting list. You have yourself. How did
Yes.
you get it?
Yes. What is the result, Your Lordship?
Now, you want what you call natural justice. But what do you say about the principles of useless formality? There are exceptions to natural justice.
Yes, I
One is
agree.
of the,
Agree, Your Lordship.
one is of useless formality. Useless formality is
Your Lordship, if you are.
you could not have been appointed at all
Yes.
at the first place. You from your own documented annexure A, so is the who is the approved candidate, but you have been appointed.
The grounds taken by the said
Can
government.
you, how can you now say that you were in the waiting list? You have come to know now. Whereas it is apparent from annexure A to your writ petition.
The grounds that said have taken, Your Lordship, they have said in the paragraph 5 of the affidavit in opposition, allow me to read, Lordship. Hence, the having found that the said appointment has been done without sanction, pause, and administrative approval of the petitioner's service approval, the petitioner's service was terminated. There are already some administrative approval, Your Lordship.
Where approval was actually for another person. You see, in the state list, the name of the petitioner was saying serial number A in the waiting list column. Whereas one so and so was shown as the approved candidate for the loan post of so and so. Consequently, the director of so and so, bearing so and so, to Sri Iman. However, anomalies were detected when it was found that the appointment of the petitioner bears the same date and order and administrative approval number to that of so and so. The successful candidate is one Namdevi.
Yes, Your Lordship.
Hence, having found that the said appointment has been, and the same appointment, the same approval
Having the
has
same.
been used.
Yes, there's some discrepancies, Your
Have
Lordship.
you taken any action against the director?
Your Lordship, that might have been taken, that, Your Lordship.
We issue direction to take
Your
that
Lordship, it seems that person has
against the
already died.
director also.
Yes,
Because what he has done is very wrong.
yes, it seems that person has already expired, Your Lordship. That is why I
Expired.
also asked you whether
Okay.
any action has been taken
So
against
any
that person.
pension he has got,
That,
his,
Your Lordship.
the family members you take.
But even in this case, Your Lordship, we are given an opportunity to then termination notice 1 month's time.
You are given.
Yes, Your Lordship, it's a termination notice, Your Lordship, within 1 month's time, and it will be deemed as terminated. Your Lordship, within that time, they didn't even, they acknowledged the representation also, Your Lordship. But we have given salary even up to that point of time. I have enclosed my annexures, Your Lordship, of the payment of salary, Your Lordship.
So you have paid him the salary also.
Even till the point of termination, Your Lordship. 30 days was given, and on expiry of that 30 days, it will be deemed as terminated, and they will acknowledge, they give a representation also, Your Lordship. That could not be considered, Your Lordship. Within the stipulated time, they have given a representation reply also. But now they are saying that termination notice has not been given. If you can kindly come to the termination notice in my affidavit, in my next year, Your Lordship. It's a notice, termination notice, 30 days, Your Lordship.
Page
15 of the writ petition, Your Lordship.
Page.
15 of the writ petition, Your Lordship.
That I've seen.
In my, Your Lordship, actually this morning, like, the senior says that he will be out of station. That's why, Your Lordship, I didn't brought my toilet from home.
Not necessarily.
That is the problem, otherwise.
Not necessarily. But there is a representation submitted by him.
Yes, Your Lordship. It was well within the time.
And did you consider that?
No, Your Lordship. Not consider, Your Lordship, because he is in excess appointment, Your Lordship.
This is a case of excess appointment.
Yes, there was,
No,
without the sanction
no,
post.
whether that person, Namdi, or
Yes.
he or she has been appointed.
Yes, Your Lordship.
So
he was
there were two
appointed as
appointment against one post.
Against one, but, and that person has made this thing, Your Lordship, made an error, Your Lordship. So on detecting, Your Lordship, we
No,
took
no,
steps.
this is a fit case for taking the money from the director. No, no,
That-
the
yeah.
state exchequer has
Yes,
lost
that's what,
in paying him.
that the state can take that.
So let me dictate.
But since Your Lordship, today's senior is not there, so I.
Senior, is he going to make it case better?
City
Who is your senior?
City Jambe, Your Lordship.
Okay. You want it tomorrow?
It's out of station for 2 days.
So Tri-State, Your Lordship,
Not the
this
papers.
Thursday, this Thursday, the battery is fixed, so we can pick it up on Tri-State.
I'll still be dismissing. With cost. Now, this is an unnecessary litigation. With you, no cost. With the senior, cost. The matter having been heard at length, matters will be taken up for further consideration on 22nd of February. And shown as part of it.
Much obliged.
Item number 42.
Mr. Counsel, I don't adjourn on the ground of senior counsels. A senior may be, he may be a senior, then I will adjourn it. But not on the ground of a senior counsel. Senior counsel is different. Senior counsels, in my opinion, is a daily wager. They get their fees on daily basis. You may have him, you may have somebody else. He does not sign the Wakalanka. He is not responsible to the client. Client's responsibility is his. So I never adjourn. You may ask in the principal secretary. Yes. On that day, it will be on cost. Yes. Yes, tell me. Set aside the impugn advertisement. Consider the case for the appointment of ER. Is there a stay order?
Yes, Your Lordship, and then it was based on a judgment by the judgment, Your Lordship, which is at page 40.
Page?
Page 40, Your Lordship.
Three. What is this? Yes, then
This, by this judgment direction of-
you were a petitioner in the earlier.
Yes, yes.
Yes,
I was
then
a petitioner. So in that case, the earlier order issued in respect of the private respondent was questioned, set aside and direction was given. The lordship then, no action was taken on the basis of this. But then, what happened was, they issued the new application.
And what is the stand of the respondent?
That my case be considered in terms of the judgment. Now, your lordship.
What is the state respondent's affidavit?
Lordship, yeah, affidavit.
It's filed on 11th August 2022.
What is your father's name?
Mention.
In Bangkok. In Bangkok. Your grandfather's name? Who is Mr. B. Nyam Song?
It's the father of the.
Father or grandfather?
Grandfather.
Your father's name is Nyamsong Phom. And your grandfather's name is what? So the land as per this document at page 21 of your affidavit is not in the name of the father of the petitioner. But the affidavit of the father of the petitioner, in the affidavit filed by the petitioner, the petitioner's father's name is different, Nyamsong Phom.
Yes.
Then,
Nyamsong.
whereas here the land belongs to C. Longson and B.
There's
Nyamsong.
two landowners.
Huh?
Two landowners, 1 and 2. The number 2 is.
Kindly see the next line. It is also found that the actual location where the building stands belongs to B. Nyamsong.
Yes, Your Lordship. B. Nyamsong.
And that till date, no compensation nor any opportunity has been given to the landowner in order to land the petitioner is the son of B. Nyamsong, the landowner. Whereas here the petitioner has filed the affidavit, have you seen in the writ petition?
Yes.
What is the name of the father? No, 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 no. See the, no, madam, can you see the writ petition? I'll see the affidavit.
My affidavit, Your Lordship.
No, writ petitioner's affidavit. Page 16.
Bangkok, Your Lordship. And Nyamsong Phom.
Is this the, and this person same?
Yes, I think that E, I think the letter E, I think that is the difference.
No, 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 one is Phom and this is B. Nyamsong. And here it is Nyamsong Phom.
Yes.
Is it the same?
Yeah, I think it's the
It's the
same.
same, Your
Your
Lordship. They are same person.
How do you know?
They the
Names are
same
different?
person. They are the same person.
Names are same.
Yes. They are shown that he has been, these are illiterate.
So,
Yeah.
no, here the name happens to be different. Anyways,
Yeah, I think the E and the letter E and B, I think there's a difference.
no, 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 no. One is Nyamsong Phom.
Yes.
That Phom is a title.
And other is B. Nyamsong. B. Dot Nyamsong.
Yes. Home is
Okay.
Right. Yeah.
But if he is banking upon his father's thing, isn't
Not
it
father,
required
it's a-
to write the name properly? If the land is B. Nyamsong. Anyways, then
There was no dispute regarding the listeners' family having donated the land.
The Lordship, what? So what, Your Lordship, what happened is here is that in the first writ petition, the condition of the petitioner was that the land was donated in 1971 by the grandfather, Your Lordship,
it is
by
not.
the petitioner's grandfather, Your Lordship. So we have a policy for accommodating appointment to those who are landowners, Your Lordship. We have a policy, as you are well aware, Your Lordship. And so I have argued that there was no written agreement, because those cases which are like all cases are not to be reopened, Your Lordship, as per the policy. But in case if there is a written agreement or oral agreement, then it has to be written through Deputy Commissioner for verification. So now in this case, Your Lordship, this honorable court comes to a finding that in the petitioner's case, the present case, they should be given for verification from the DC, because they submitted before the court that there was a verbal agreement. And therefore, accordingly, verbal verification was sent, Your Lordship, the first verification. However, it was not clear. The clarification that was brought to me was not clear. So I asked the department to seek a clarification whether there was a specific oral agreement between the petitioner and the petitioner's grandfather, petitioner's family with the government. Now, what happened is that I received, the government received a clarification. That is my annexure 23, Your Lordship.
Page 23.
Page 23, Annexure 7, Your Lordship.
Yeah.
Your Lordship, I'll just give, read the operative portion, sir. On the subject cited above and inviting a reference to your letter so-and-so, that is so-and-so, I have the honor to state that in interaction with the next of kin of Shri N. Bangkok, that is the petitioner, Shri B. Nam Xiong Pong, that is the father of the petitioner, it has found that there was no verbal or written agreement between the landowners and the agents of the government in respect of the plot of land on which the present GHS Tamil was established under the establishment of the DO Longland, then owing to ignorance. However, despite several attempts made by the aforesaid genuine landowners for appointment to the post of grade 4 at GHS Tamil, he has been deprived of his due right by the concerned department, wherein other parties have been appointed to the said post over the years. Therefore, this has compelled him to resort to legal action. Now, this is the first reply. After that, Your Lordship,
Then there is a challenge to this document?
No. Your
No,
Lordship,
what is this petition WBC 60 of 2020?
yes, because
Is it
this
60?
This 60 came up because Your
this
Lordship.
This
Your
was
Lordship,
during the pendency of the.
yeah, this was during the pendency of the case we sought for instruction, and this
Then
instruction.
let us come to page 26.
No,
of
Your
your
Lordship,
affidavit.
very important thing, Your Lordship, I'll come to that, Your Lordship, but on 26/11/2021, that is page 25, Your Lordship. The matter came up on 26/11/2021. 26/11/2021. On this day, Your Lordship, I submitted that we have received a verification report, a clarification report stating that there was no verbal agreement, and therefore, in light of that, the matter can be disposed of. But the petitioner insisted that I should be filing my affidavit. So the court gave a direction, and I saw 3 weeks to file an
Now kindly
affidavit.
come to page
Meantime,
26.
on 27th, Your Lordship, the DC wrote again that
26, page 26.
26, Your Lordship. DC has wrote to our principal director to the government stating that the petitioner has come before the court, before them, and clarified that they want to retract the statement. That now there was a verbal agreement and there was a miscommunication, and therefore, basing on that miscommunication, he has stated that there was a verbal. There was no verbal. Otherwise, there was a verbal agreement. That is what the petitioner has stated. Has retracted the statement, Your Lordship. That is only after the submission. I have already made a submission before the Honorable Court. And after that, Your Lordship, this clarification comes. So what I'm stating before this court is this document is an afterthought document. This action was taken only after I submitted before the court, only after the learned counsel has come to know about this.
What do you say about page 21?
My affidavit, Your Lordship.
Yes. Let us read that.
Yes, Your Lordship. That's why, Your Lordship, there's a condition, Your Lordship.
No. Read the very
Your Lordship,
inviting reference to the subject stated above.
Yes, Your Lordship. This document was also an annexure in the first writ petition. And basing on this documentation, the Honorable Court has given a direction that whether there was a verbal agreement or not. Your Lordship. Basing on this document, because this document was a part of a writ petition, the first writ petition, Your Lordship. And basing on this, we were actually the DC was directed to go for verification, whether there was a verbal agreement or not. Because all the cases prior to 1960, it's not to be reopened.
What is the age of this person concerned who gave this particular thing? The retraction happened.
Retraction, Your Lordship, that the
Yes,
petition.
what's the age of your father?
Lordship, I have to ascertain it. The age of the father, I cannot give exactly, Your Lordship, because.
Okay, what is your age?
As per the affidavit, Your Lordship.
Actual? 27. So 27 in 2020. So today he will be around 31.
Yes. Your Lordship. This was done during the. What happened was the.
That will only come, no, that will come into play if the case was operative before somewhere in 1971 or 1980s or 20s. Now a new policy has come up, Lord, because of the judgment of division bench. There was a direction from the division bench, and this policy, comprehensive policy, was brought out. And therefore, all cases will not be taken up.
What is the new policy?
Your Lordship, Lordship, then we have to go back from. I think we have not annexed that new policy.
Page 36, Your Lordship, of my. Page 36 of my petition.
Page 36. This is a new policy.
Yeah,
This
this
is
is
the policy.
comprehensive policy that has been brought up by the, and we're.
This came out during the pendency of the earlier petition.
2(3)(a) will be relevant.
Now, has the deputy commissioner kindly come to 3B? Has the deputy commissioner taken into consideration the witnesses, other witnesses? That there was, because he says that the village authority, as you can see from paragraph 3 of his reply, he says that you see there is no question of it, there was a misunderstanding.
Miscommunication, but how can there be
It's a
miscommunication?
misunderstanding, but actually if you take the evidence of those village authorities who were present or those people, they will also tell the same, but have the deputy commissioner taken the witnesses of those persons?
So that
That is not apparent.
yeah, that we will have to seek answer, but now.
Because
Your Lordship-
you see, if that be so, then you have to comply in terms of 3B. Have you taken that?
Your Lordship, that's why that, okay, that part I have to clarify, Your Lordship, because.
We give
even
you,
the
we do
first-
one, no, we do one thing. From the letters of the deputy commissioner,
Yes.
more particularly page page 26. Okay. Page 26. He also says that he has said that it has happened out there, retract his statement and so and so. Earlier, you see, ADC has at page 21, which I've asked you to read.
Yes, Your Lordship.
At page 21, the ADC says so. Okay. Then comes, you ask them to find out.
Yes, Your Lordship.
Then the deputy commissioner comes up out here and says that kindly see at page 23.
Yes.
Written agreement between the owner and the agent of the government in respect of which the present so and so was established under the establishment year. However, despite several attempts made by the aforesaid genuine for appointment, he did not get it. Then I had the honor to state the interaction with the next of the kin of so and so. And it has been found that there is no verbal or written agreement. This is also interaction.
They have come to the office personally and.
Understood? That
Yes,
is
Your-
also an interaction.
Yes, Your-
That interaction they have stated and on the basis he said. But on the other hand, this very person if you see on the later portion of that letter, this very person has been trying to get an employment. And you see that. However, then you see the written area here, no verbal or between the area agents of the government in respect to the area was established in area. Then owing to ignorance, they must have said that we didn't know at that point of time that there was a requirement of an agreement or not. That must have been stated. However, kindly see, despite several attempts made by the aforesaid genuine landowners for appointment to the post of ER, he has been deprived. Means, when he is, why is he asking for the job? Why is he asking for the job? He has been deprived. He will be obviously asking because there must have been something. There may have been a misunderstanding. Then what is your requirement? You have to look into the evidence of the witnesses.
Yes, Your Lordship, that's very important, Your Lordship. However, Your
Which
Lordship,
have not been done.
One thing is very important, the land has been donated free of cost, Your Lordship. That has to be taken into consideration. After donating the land free of cost, can they come again for, if there is a condition, we will give you land ownership, grant for appointment in lieu of the land that we have given, then that's a different issue. But here in
No,
1971.
madam, kindly see your, this page 36.
26, Your Lordship.
36 of his writ petition.
Yes, Your Lordship, 36, that's why, Your Lordship.
No, kindly see 2A, paragraph 2.
2, Your Lordship.
Yes.
All cases where administrative headquarters and block headquarters were set up in various parts of the state on land donated freely by individuals, village, or people of that area should not be reopened for compensation or for employment in consonance with the policy brought out by Memorandum 26, 1977.
Then 3A.
Yes, Your Lordship, 3A in other cases prior to 26, 7, 2005, and subsequent to setting up of administrative and block
on freely donated land.
Your Lordship, where a specific written agreement exists provided for employment.
So that means irrespective of a donated land being freely, there can be a written agreement.
Your Lordship, if there should be a written agreement.
No,
That's why, Your Lordship. If there is
therefore, 3B comes in. Oral agreement, if it is there, then you have to look into these.
Yes, Your
You have to
Lordship.
take into account the witnesses.
I agree, Your
Have you
Lordship.
taken into account those witnesses? Nothing.
To that extent, Your Lordship, I agree with Your Lordship that we have to take a certain from the Deputy Commissioner, we have to start instruction. But my only thing is that I'm not against this order also, since there was a direction for verification, whether there was an oral or not, and the petitioner's father as well as the petitioner, they admitted that like there was no verbal, there was a retraction, and that was my only condition, whether that can be admissible, because that was an afterthought document, and that's why I have stated they have come before with uncleanness. But if Your Lordship has observed that there should be a witness, then Your Lordship.
I'm not saying, kindly see 3B.
Yes, Your Lordship, so as per this, the Deputy Commissioner and the
Let
letter.
us read 3B.
Yes, Your Lordship,
Yes, let us not trouble her with her voice. You do it.
Lordship, God is Your Lordship.
Let us
Lordship, it's
read
clear.
No, Mr. Counsel, let us read 3B.
Yes.
So that madam can hear it patiently.
No, Your Lordship, it's clear.
I read. If there is any claim for providing employment as a result of oral agreement, the department concerned shall refer the matter to the Commissioner of the district concerned, who shall examine such claim carefully, including whether any employment or any other facility, including contract or supply order.
So what is his source of what is he required to look? He is to inquire as to whether any other employment has been given, if there is an oral agreement.
Yes.
And then see. Written statement from witnesses, that is the government officials of the concerned department, district administration and village function is present at the time of such year shall be taken by the Deputy Commissioner.
Yes.
So what's this taken?
This for Your Lordship, that let the seated instruction.
So if that is not taken, then he will make the recommendation. So here is a case that he had an interaction with him and he said that no, but we have been trying our best to get a job. We are not being in a position out there, but we did not have an oral agreement on account of we did not know. That is what he stated before the Deputy Commissioner on the basis thereof. Whereas all other persons
Yes.
nearby got it. That is the deputy commissioner's letter. On the basis of which they later on they came up and made it very clear. Then look here, actually this was a misunderstanding. There was an oral agreement to that. So what is the requirement of the deputy commissioner? Deputy commissioner therefore is required to again look into as regards the witnesses as to whether there was an agreement or not. Other witnesses.
Yes, Your Lordship.
That part to your lordship, since the
Your
statement has
Lordship,
been
in
retracted
my
now.
affidavit in reply, the village council has clearly
No, that is not disputed, Your Lordship, but
the village council, that there was an both states.
You do one thing.
Yes.
You have filed a reply. You file an additional affidavit bringing that.
No, this is in my affidavit in reply to the.
Oh, you have given it, huh? Then I think we can do one thing. We can, on the basis of this,
Page 5 of my affidavit in reply.
Page?
Page 5 of my affidavit in reply. In fact, all these were submitted to the deputy commissioner, even the deputy commissioner's office signature is also received also there. That's fine. Annex 1.
so this is given by that. The
Village council.
Village council.
Village
And
council.
then, what is this
And then-
retraction by you? And then,
This is also.
what is page 8?
Yes,
This is the earlier one.
yes, these are earlier.
There was an oral agreement. When the letter dated even so and so, therefore authority may kindly consider so and so. And seeking administrative clarification, verification of the genuine landowner so and so. In this regard, the person in this regard clarified that there was an oral. Authority may kindly consider. This is. Why are we enclosing this 14/1/2024 so many times? So this document is earlier there also.
Yes, now, when this was submitted to the deputy commissioner, but in the affidavit, they have been silent. In the affidavit in opposition. They have only enclosed the petitioner's retraction. And the letter. of
We
the-
do one thing, madam, we set aside that advertisement because the advertisement
no,
has.
that is already set aside, Your Lordship. That already we have set aside because.
Oh,
now
yeah,
we
that
are-
is no longer
We
there.
are only on this issue only.
Only this issue. So
Yes, no
we do one thing, we dispose of this writ petition, directing the deputy commissioner to do and carry out an exercise in terms with 3A.
Yes.
Your
And the petitioner and his father, along with the village council, should be at liberty to submit whatever witness and they will show and they will submit whatever it is within a time span.
Yes.
30 days, you do everything,
Your Lordship.
submit everything, and the deputy commissioner thereupon will decide what to be done. And on the basis of that decision, thereafter you take.
Yes.
What do you say?
Your Lordship, that is already anticipated they will get. No, I was only on that retraction. Otherwise, like, if they're entitled, who am I, Your Lordship? They're entitled as per the law. My only thing is that they have retracted the statement.
You see,
How can
no,
they retract their
no,
own?
madam,
word?
I would have, see, you have to also consider,
Yes, Your Lordship.
yes, let us assume they have retracted. Assume. But the fact remains, maybe a thing that at that point of time they may not have. One has to understand that, you see, apart from that, the equity council, nearby all lands, all the other persons have got. This is what the statement is of the deputy commissioner.
That is the statement made by the petitioner and.
No. This is what the deputy commissioner says. Kindly see this. In that, in the letter where the deputy commissioner says that all other persons have got it. Kindly come to page 23 of your affidavit.
Lordship, this segment will sum up by the last line. Therefore, this has compelled him to resort. The deputy commissioner is only projecting what the petitioner.
However,
has
despite several attempts made by the aforesaid genuine owner for appointment to the post of remand, he has been deprived of his due right by the concern wherein other parties have been appointed to the
The
said
said
post
post over
over
the
the
years.
years.
Therefore,
Therefore,
Your Lordship,
this has
this has
compelled him
compelled
to resort
him,
to
Your
legal
Lordship.
action.
This is just a projection of what the petitioner and the father has stated. It's not a statement of the deputy commissioner.
Chalo. Let me write it. The instant writ petition has been filed challenging an advertisement bearing number ED/EST/GR dash Roman 4 APPT/DEO dash LLG/2017, and further seeking a direction upon the state respondents to consider the case of the petitioner for appointment to the post of night chowkidar at GHS, Tamlu on land ownership basis on the basis of the directions passed by this court in its judgment and order dated 29/11/2019 in WPC number 6/2018, and also in accordance with the notification dated 5/3/2018. The facts involved in the instant writ petition is that the petitioner herein is that the grandfather of the petitioner had admittedly donated a plot of land measuring 250 into 105 square feet in the year 1971 without taking any compensation. It has also been mentioned that together with the petitioner's grandfather, two other persons, namely Sri Lungsem Phong and Sri Henel Phong, paragraph 4, also donated land for the establishment of the said school. Though among the three, the bigger portion of the land was donated by the petitioner's grandfather.
Yes.
It has been also alleged in the writ petition that the Deputy Inspector of Schools had given verbal assurance that the landowners would be given preference in appointment to grade 4 post. However, no such appointment were given to the family of the petitioner, in spite of submission of various representations. On 31/5/2017, a vacancy arose to the post of night chowkidar at GHS Tamlu on retirement of one Sri Bongsong Phom, BONGSHONG Phom. Accordingly, the petitioner duly submitted a representation for consideration of his appointment to the said vacant post on land ownership basis. On the basis of the said application, The DO Longlen, Lung, forwarded the petitioner's application to the respondent number 3, mentioning that the petitioner was the real landowner, and despite donating a large area of land, no post of grain 4 had been allotted to him, and he is the most deserving candidate. The DO further recommended the petitioner's case for consideration against the existing vacancy. Be that as it may, ignoring the petitioner's application, the government, via a letter dated 6/12/2017, conveyed the approval for appointment of one Sri P. Phamnya, Phamnya, Phom, who belongs to a different village and was not a landowner candidate. On the basis of the said recommendation made by the government, said approval given by the government, the said P. Phamnya Phom was appointed on ad hoc basis as a night chowkidar at GHS Tamulpur by an order dated 11/1/2018. The petitioner being agreed thereupon preferred a writ petition before this court, which was registered and numbered as WPC number 6K of 2018, seeking a writ in the nature of certiorari for the purpose of quashing the appointment of Sri P. Phamnya Phom and to direct the state respondents to appoint the petitioner in accordance with the notification dated 6/3/2000. The said writ petition was disposed of by the judgment and order dated 29/11/2019, whereby the appointment of Sri P. So and so Phom was set aside and quashed. Further to that, this court directed the respondents to take fresh process to appoint suitable persons as per law, giving weightage to the landowners like the petitioner if there was any oral agreement or assurance from the government through its agents as claimed by the petitioner in the said proceedings. Paragraph 8 of the said judgment being relevant is reproduced hereunder. You'll find it at page 47, 48, and 49. Pursuant thereto, this court directed, pursuant thereto, the petitioner submitted the judgment passed by this court to the various respondent authorities. And respondent authorities on 3/12/2013 or 3?
3rd December.
Huh?
3rd.
3/12/2019. Subsequent thereto, by another communication dated, what is this date?
17/2/2020, your lordship will go up to the top in the first page.
Pursuant thereto, on 17/2/2020, the petitioner had also submitted a representation to the Principal Director, School Education Department for consideration of his case. In spite of those documents, in spite of the directions passed by this court in its judgment and order dated 29/11/2019 in WPC number 6K/2018, as well as the representation submitted by the petitioner, the respondent authorities, more particularly the respondent number 3, respondent number 3 had issued an advertisement on What is the date?
This is on.
Had issued an advertisement on 21/3/2020 in the Nagaland Post for filling up the post of one night chokida at the government's high school, Kamlu, under the establishment of the district education officer Longlang. This advertisement has been put to challenge by way of the instant writ petition, as well as seeking directions as already stated here in above. Pursuant to the filing, at the time of this writ petition was filed on 26/5/2020, and when the matter was taken up for motion on 1/6/2020, this court stayed the impugned advertisement dated 21/3/2020. 21, na? 21 or what? 21/3/2020, which was enclosed as Annexure M to the writ petition. The record reveals that during the proceedings of the instant writ petition, during the pendency of the instant writ petition, there were certain significant developments, inasmuch as on 23/7/2020, the principal director of the Directorate of Social Education sought for instructions from the Deputy Commissioner Longlang as to whether there was any oral assurance or agreement from or with the agent of the government with that of the petitioner. No, with the agent of the government in respect to the land donated by the family of the petitioner. It was also made that if it was found that there was any assurance or an agreement the respondent authorities, it was also mentioned that if there was it was also mentioned that if it is found that there was any assurance or agreement, the case of the petitioner was required to be considered for appointment to the post in question by giving due weightage. So, under such circumstances, the Deputy Commissioner Longlang was requested to treat the matter urgently. Thereupon, the additional Deputy Commissioner, Kamlu, gave a report to the Deputy Commissioner Longlang by the communication dated 12/8/2020, In the same report, it was specifically mentioned that the area of the compound of the present GHS building is located in the land belonging to two individuals, namely, number one, Sri C. Longshen, Longshen, dash on the eastern side, and Sri B. Nyamsong, Nyemshong, on the western side. It was also mentioned that the actual location where the building stands belonged to Sri B. Nyamsong, and till date, no compensation nor any other opportunity has been given to the landowner in lieu of the said plot of land. It was also mentioned that as per the traditions and customs of the Nagas, the claim made by the petitioner as landowner was justified. Full stop. It is not known as to whether the said communication issued by the additional Deputy Commissioner Kamlu was taken note of by the respondent authorities. However, on 16/11/2021, the Deputy Commissioner Longland was again directed by the Principal Director to submit administrative clarification as to whether there exists any arrangement, verbal or written, between the families of the petitioner and agents of the government in respect of the plot of land on which the GSHS Tamlu was established under the establishment of the DEO Longland. Subsequent to the said communication dated 16/11/2021, the Deputy Commissioner Longland, Nagaland, informed the Principal Directorate by the communication dated 23/11/2021. Let me come back. Madam, what did I say in the last line? The contents of the said communication primarily contents of the said communication is very relevant for determination of the dispute for which the contents are reproduced herein under. From the above contents, it reveals that there was an interaction between the petitioner, father, and the deputy commissioner, wherein the petitioner's father informed him verbally that owing to ignorance, there was no verbal oral agreement. However, it was also informed that there were various attempts being made by the petitioner's father, by the petitioner and his father, for the purpose of getting a job, for getting appointment to the post of grade 4. But they have been deprived of, whereas other parties have been appointed to the said post over the years. This document was placed before this court on 26/11/2021. When the said aspect was placed, 26/11/2021, by the government advocate appearing for the state respondents. This court, by an order dated 26/11/2021, directed the state respondents to file an affidavit. In the meantime, prior to the filing of the affidavit, further development took place inasmuch as the deputy commissioner wrote another communication to the principal director on 14/1/2022, stating inter alia that on account of misunderstanding, miscommunication, it was mentioned on account of stating inter alia that a communication was made by the father of the petitioner on 13/1/2022, stating inter alia that it was on account of a miscommunication. It was on an earlier occasion stated that there was no oral agreement for appointment to the post of grade 4 between the landowners and the agents of the government in respect to the plots of land on which the present GHS Tamlu was established. By the said communication dated 14/1/2022, the Deputy Commissioner therefore requested the Principal Director to consider the case of the petitioner for appointment on humanitarian ground. All these aspects were brought to the notice of this court by the respondent numbers 1 to 6 by filing an affidavit in opposition on 11/8/2022. It is, however, relevant to take note of that in the said affidavit in opposition, it was also stated that in the said affidavit in opposition, the respondents have taken a stand that the retracting of the stand by the father of the petitioner was an afterthought document which cannot be admissible. It therefore appears from a perusal of the said affidavit in opposition that the respondent authorities are not inclined to consider the case of the petitioner. The record further reveals that an affidavit in reply has been filed by the petitioner to the affidavit in opposition filed by the respondent numbers 1 to 6. To the said affidavit in reply, a clarification of the genuine landowner of GHS Tamuli DEO Longlang, DEO Longlang, was submitted to the Deputy Commissioner Longlang by the Chairman of Kamlu Village Council, stating inter alia that there was an oral agreement. This court have duly heard the learned counsels appearing on behalf of the petitioner as well as the respondents. Their submissions have been duly noted. From the above facts, it is apparent and admitted that the land wherein the GHS Kamlu is situated is a portion of the land which have been donated by the grandfather of the petitioner. This aspect of the matter have been duly admitted by the responding authorities in the communication dated 12/8/2020. Now, under such circumstances, the question arises as to what are the parameters to be followed by the respondent authorities. In this regard, reference can be made, and in this regard, this court have taken note of the notification dated 5/3/2018 issued by the Chief Secretary to the Government of Nagaland Land Revenue Department. From a perusal of the same notification, it reveals that the same notification was issued pursuant to an approval by the Cabinet. The policy with regard to appointments to grade 4 posts under the Government of Nagaland on land ownership basis. From a perusal of the said notification, it reveals that as per the notification number LR/4-3/KOH/2003 dated 26/7/2005, it has been the policy of the government not to acquire any land free of cost, and all land shall be acquired on payment of full compensation as determined in by law. It is also seen from a perusal of clause 2 of the said notification that all cases where administrative headquarters and block headquarters were set up in various parts of the state on lands donated freely by individuals, villages, or people of that area should not be reopened for compensation or for employment in consonance with the policy brought out by memorandum number LR/2-135/76 dated 26/1977. However, in respect to other cases prior to 26/7/2005, the government, the notification duly takes care of as to how such lands, how such claims are to be settled. Clauses 3A, 3B, and 3C being relevant is reproduced herein below, page 36. In the instant case, it is an admitted fact that there is no written agreement. Under such circumstances, clause 3A is not applicable. It is the specific cases of the petitioner herein that there was an oral agreement. However, from the communication dated, however, there seems to be certain disputes which have arisen in view of the communication dated 23/11/2020, 23/11/2021 and 14/1/2022. In the opinion of this court, clause 3B is the relevant clause on the basis of which the Deputy Commissioner, Longlang, was required to address the issue. A perusal of clause 3B categorically stipulates that as to how the said issue is required to be resolved. The same requires to be done by taking written statement from the witnesses, that is, the government officials of the concerned department and the district administration and village functionaries present at the time of such oral agreement should be taken by the Deputy Commissioner. In the instant case, it is not seen as to whether the Deputy Commissioner have taken into account the witnesses, the statements of the witnesses, and more particularly, the stand of the village council, which is apparent from Annexure Roman 1 to the affidavit in reply. Under such circumstances, this court therefore disposes of the instant writ petition, thereby directing the District Commissioner, Longlang, to decide as to whether there was any oral agreement entered into between the petitioner's father, petitioner's grandfather, between the family of the petitioner with the agents of the government at the time when the land was donated for the establishment of the GHS Kamlu. In doing so, the Deputy Commissioner, Longlang, shall take into account the written statement of the various witnesses and thereupon shall make the necessary recommendation to the principal director.
Your Lordship, if the witnesses should be of the should, Your Lordship, present at the time. At the time when
Understood,
the oral.
understood.
That may be
No, no,
recorded because Your Lordship,
he knows, no, it is given out.
usually Your Lordship, they
It's
use the
okay.
word.
What did you write last? Shall take into account the written statement of the witnesses, and thereupon shall make the necessary recommendation to the principal director. Full stop. This court further grants 30 days of time to the petitioner to submit all the written statement of all the witnesses in support of the petitioners before the district commissioner Longland. Full stop. Thus, the district commissioner Longland shall also be at liberty to take the evidence with the written statement of the witnesses, of the government officials of the concerned department, as well as the district administration at the time of such oral agreement in deciding, in making its decision, and thereupon submitting the recommendation. This court further directs that on the basis of the recommendations so made, the principal director what?
School education.
Principal director of the respondent number 3. The respondent number 3 shall take due the principal director, school education, Nagaland, shall, on the basis of the recommendation, proceed in accordance with the directions which was passed by this court in its judgment and order dated 29/11/2019. The said exercise be completed within a period of 4 months from the date of the incident from the date of the incident judgment, or no, from the date the petitioner submits the statement of all its witnesses, along with a certified copy of the incident judgment. With the above observations and directions, the petition stands dismissed. Just one line. Before parting with the record, this court sets aside the said advertisement, taking into account the said advertisement had already lapsed, and depending upon the recommendation, the principal director, school education, shall take necessary action. Item number 43. Yes.
Sure. He's in service for last 25 years. Lordship is still in service, Lordship. Appointed as Workshop Tribal, Lordship.
Regularize.
Lordship queries for regularization of the service.
How?
This is government standing policy, Lordship. It's about the standing government policy, which was formulated on 22nd September 2004, Lordship. It holds the field, Lordship. As per the policy, Lordship, 50% of vacancies arising in a year has to be reserved for regulation of workers employees, Lordship. And the remaining 50% to be appointed to all procedure. Now, Lordship, I have sought information from the department, Lordship, as to the appointments made from the year 2009 till date, Lordship. And till date, in the sense, Lordship, at the time of filing the writ petition. So, in the last 10 years, Lordship, 72 regular appointments were made. Drivers, 72 altogether, Lordship. Now, going by that office memorandum, Lordship, at least 36 has to be accommodated for the workshop employees. Now, as per the seniority position, I'm in the second place, Lordship.
You're
Serial number
retired?
two. Lordship.
Have you retired?
No, Lordship.
You're working?
Yes, Lordship. I'm
You're
very
number
much-
2?
Yes, Lordship.
Yes, madam.
He's not covered by the policy yet as of yet, because his seniority list is at number 8, Your Lordship, which I had annexed in my affidavit, Your Lordship. In fact, there are two policies with regard to regularization of work charge employees, and both the policy, he's not covered by both the policy. He does not come under both the policies, Your Lordship. And in my affidavit, para 5 of my affidavit, Your Lordship, and the annexure is page 7, Your Lordship. If I may be allowed to read out paragraph 5, Your Lordship.
He's number 8.
Yes, so this is the.
And your
seniority list.
stand is that he will be considered only after the others.
Yes, Your Lordship.
That's your stand.
Yes, Lordship. And also, yes, Your Lordship, as per 2015 OM, Your Lordship, which is also for regularization of work charge employees, Your Lordship, he has to be in service for 30 years as on 17 March 2015. And
Yeah, what is the name of the petitioner?
It's Watimongba,
What will find it serial number?
seal number 8, Your Lordship. Watimongba.
He, date of birth. Date of joining is 98.
Lordship.
Date of joining is 98. So, how many years you got? 30?
30 years, as per the new regularization policy, Your Lordship.
2015.
Yes, Your Lordship.
17/9 or 7/9?
17/3, Your Lordship.
17/3.
Yes, to be 30 years in service, Your Lordship, to be regularized, Your Lordship. So around.
25.
We have to
So he
wait
has
for
to wait
another
for his
some
turn,
time.
Your Lordship.
That's why I agree with the fact that my case cannot be considered under that 2015 Lordship. Whereas Lordship, there's
No,
another
no,
policy.
but madam, tell me one thing. How do you take care of serial number 4 in that list? Why serial number 4 is 99, date of appointment? Why he is at serial number 4, whereas the petitioner in 98 is in serial number 8?
Yes, Your Lordship, as per that, I have no instruction, but even then, Your Lordship, his, three, those persons who are seniors to him, they are yet to
No,
be
no, how can
regularized, Your
these
Lordship.
people be senior to him? Kindly see, okay, number 1 is okay, number 2 is okay, number 3 is okay. How do you place number 4 above the petitioner? How do you place number 5 above the petitioner? How do you place number 6 above the petitioner? Tell me.
Yes, Your Lordship, but even then, there are two more persons who are
Understood,
seniors, Your
but
Lordship.
then also,
Yes,
wouldn't
Your
his
Lordship.
serial number
sir.
be different?
In that aspect, you have to seek clarification, Your Lordship.
Next Monday.
Tuesday, Your Lordship.
You want it tomorrow?
Your Lordship,
Tomorrow, Tuesday?
no, coming Tuesday, Your Lordship, next week, Your Lordship.
Lordship, I appreciate your Lordship's opinion about the serial position, Lordship. Now, as far as 1 to 6 is concerned, the post is different, Lordship. Sectional assistance. Sectional assistant, Lordship. 1 to 6, Lordship. Now, my contention is that I'm at serial number 2 because there has to be different seniority lists for different categories of posts, Lordship.
But even
Sectional
then-
assistants, Lordship, they are different.
Even
I
then, Your
cannot be
Lordship-
accommodated to the post of sectional assistant, Lordship. I'm a driver, Lordship.
And there's another driver who's senior to me.
Yes,
He has
what
to be
I read
regularized,
fact.
Your Lordship.
Serial number 7 is placed above me. I do not dispute that, Lordship. My contention is that I'm placed at serial number 2, Lordship. And when there are 72 appointments made, Lordship, what was the difficulty for the department to consider, Lordship? I'm not saying that I should be considered ahead of my senior, Lordship, but
But
they
how
have
can you
to-
be considered as per 17/3?
Lordship,
How can you be considered as per 17/3?
Lordship, my prayer is only in terms of the office memorandum 22/9/2004.
But you see, if you see 22/9,
Lordship.
2004,
Lordship.
it stipulates for work charge.
Yes, Lord.
Okay. Now, if you see 17/3, it takes care of all others, including work charge. And me and Justice Sato, while sitting, had delivered a judgment that 17.3 remains and 22.9/2004 remains till it is not contrary to 17.3. And how do you get into 30?
2015 is pertaining to those employees
You-
who are enjoying scale of pay and who
You-
have completed 30 years. And employees who
Oh, you have time. You are 70. You are now 54. Isn't it?
Logic.
You are 54. So 30 years. 30 years will be 2038. Your retirement will be how much as per this? 60.
60 or 35. Whichever is earlier, Logic. 35 years
60
land
will
of
be 2030. 2030.
Logic.
Your retirement age. And then what will be your
Length of service, Logic, I have another 10 years. Logic.
Hmm?
Length of service, I have another 10 years. I have
Oh,
completed 25.
You have to wait.
But in terms of the 2004 OM, Logic.
How do you take out because if you see 17, read 17.3.
Yes,
Very clear.
It categorically says that all aspects have been taken into account, including work charge.
Logic, kindly come to the clause Roman key, Logic.
No, kindly
Roman
come.
key.
Where's the office memorandum? 17.3.
Annexure 9 of the writ petition, Your Lordship.
Page 34. Logic.
Yes. You see, read it. On due consideration of the report of the work charge and Casual Employees Commission, and in compliance with the judgment and order of the Honorable High Court, the Governor of Assam is pleased to introduce the following scheme for regularization and absorption of the work charge and casual employees. So, as on this, it is 17.3. 17.3 permits that you can only come after 30 years. We have completed 30 years or more continuous service as on 1/1/2015 will be regularized by conversion of their post into a personnel. And there is another one, where is it? Here. In respect of those work charge employees and casual in scale of pay and who have completed or will complete 30 years of continuous service after remand, their cases of regularization will be taken subsequently in 2 batches as on 1st of July and remand every year. The procedure and terms and conditions will be same as laid down in this AOM. So,
Logic for a moment, if Logic may kindly consider the Roman 3, the next problem. May I read it, Logic? The existing scheme that refers to the 2004 OM, Logic, for regularization of workplace employees against normal vacancy is being modified. And the quota for workplace employees stands enhanced from 50% to 67%. For the next 5 years, effective from 1/1/2015, which has lapsed, Logic. This existing scheme will also be applicable for the casual employees appointed on full-time basis. So even the 2004, the existing scheme also. still
Mr.
holds
Counsel,
Logic.
what you are arguing was held by the single bench,
Logic.
that this scheme is only valid up till 2015 and thereafter it is not.
Logic,
And this
my
has been
humble
interfered
understanding,
with by the division bench.
My humble understanding.
Where is the earlier counsel who was appearing?
But it so happens that I was also one of the appellant in that case. Read April 6.
Yes. That judgment, I have taken note of this. And said that only for this period it will be 67%. And then again it will revert back to 50%.
50%.
So,
but 50% remains, Logic.
So 50%, but as of now you don't have the competence.
Logic, as far as 2004 is concerned, Logic. The length of service.
2004 is gone. 2004, you see, therefore, these clauses 2 and 3 duly takes care of the 2004, saying that okay, but 2004 now stands modified. You cannot have this 2004 any further. Because you can't have 2004 on one hand and 2017-3, 2015 together, both. If you have both together, it will lead to a chaos, isn't it, madam?
Yes, Your Lordship. And Your Lordship, even the petitioner has made a categorical statement saying that the 2015 OM is holding the field, Your Lordship.
He need not say,
His-
this court had division bench have
Yes, Your
already
Lordship.
held it.
That's
So
why. He
whether
cannot go back, retract his
I think not,
statement, Your Lordship.
so that you have no case, I think you have
What's
to
in the
wait.
case if I may be allowed to place the judgment tomorrow, Lordship?
Which one?
The division bench's judgment,
Oh,
Lordship.
yes.
If the matter can be taken up tomorrow.
Tuesday, Your Lordship, because coming Tuesday,
Tomorrow
because
is
I have
Tuesday, Lordship.
some other matters tomorrow as well, Your Lordship, which is listed for hearing, Your Lordship. So, on
You have
Tuesday,
other matters?
which is listed tomorrow for hearing, so.
So?
So this matter may come up next week, Your Lordship.
No. I'm in your favor. Then you need not argue any further. Unless I hold that the division bench judgment was wrong.
Yes, sir.
And it is a very difficult thing.
With regard to the instructions, so.
What
I was
instruction?
referring with
Not
regard to-
required, nothing. That is not
If
required.
that's the case,
No, first of all, we are to consider as on date, the writ petition is ripe enough to be taken up.
Yes, Your Lordship.
Or we are still in the raw mango, what you call. His heir will only come, his right will only fructify at the time when he has he completes 30 years. So 30 years will be on 2038,
Another 5 years.
2028,
28, Lordship.
2028.
Yes, Your Lordship.
28? 28. 28 plus 2 years. On 28. So this repetition as on date, it does not. But as on 2028, his right will accrue. And as on 2028, I can have it on Thursday. You get one instruction as to why you have taken the sectional assistant above him. Because as of now, this court is not going to pass. But while dismissing or saying anything, disposing of, this court will duly say that 2038 his right will accrue, 28. But at that point of time, the serial list also needs to be taken note of why the sectional assistant is put above the driver. Because you don't have, as per the 17-3-2015, a specific thing that this person will be given a preference than them. That is not there. So you need to get your instructions as to why he will be number 8 and not number 4. He should be otherwise number 4. Or if you hold it as per the driver for drivers, it will have its separate cadre. For sectional assistant, it will be separate cadre. Because you see, the vacancy of a sectional assistant cannot be filled up by a driver.
Your
And the-
Lordship, if I may, Your Lordship, the seniority list which I've annexed in my the counter affidavit, it's with regard to a particular division. So in that division, he's at serial number 8, Your Lordship. So that's why maybe like all the work charge.
No. Therefore,
Yes, Your Lordship.
he may be. But why if you are going as per the seniority, then he should be number 4.
Yes, as per that joining date of appointment.
Unless you say, or there is something to show that the sectional assistant requires to be given more preference than the drivers. And not only that, let's see the stepmotherly treatment given to the others. Yes. Now the drivers are to be given preference from Jugali. Because then if we hold there, you have people from 1993.
Yes, Your Lordship.
These are people from 1993, number 12.
Yes, sir.
You see, he's from 1993. He therefore jumps to number 2.
Yes, Lordship. Going by the need of appointment.
But the filling up of a post or regularization is based upon the cadre. Now, in the cadre, you will have a driver post, a sectional assistant post, or a jugali post. Now, can a driver be put out there in the jugali post? No, neither. The jugali can be made a sectional assistant. So the vacancy has to be taken into account against that driver to driver. So you get your instructions on that, huh? Thursday.
My ample submission also. If I may be allowed to place an instruction in a similar situated case, where conflict also arose, whether OM 2004 and 2015 still operates, an instruction was sought from the department, the PNAR department more particularly. The
That I have
department-
really, I have
Yes,
quoted.
Yes, Lordship.
I have already quoted that aspect in the judgment.
And it says that both are in operation, Lordship.
I said, therefore I held it out there that 2004 office memorandum will be operating in so far as it is not inconsistent with 17.3. Now 17.3 categorically mandates 30 years. How do you take care of that? That is the main problem. And that is a division bench judgment.
There can be situations where there are numerous vacant posts, but for want of complete 30 years of service, Lordship, those posts will be left vacant. Lordship.
You see, at first, when I was writing the judgment, I thought of saying that 2004 office memorandum is no longer there. But I did not do only one reason. If I have done that, it would have far-reaching consequences upon all appointments from 2015. That is why I kept it out there to keep it that till it is not inconsistent, 2004 will remain. But the requirement 30 years is there. Because that was the specific submission of the earlier councillor.
Lordship.
His specific submission is he should have got it.
Lordship.
Mr. Joe was there. Yeah, he was there. He was one of the. Otherwise, you were also there.
Lordship.
So otherwise, but you only get this thing because this court will, while disposing it off, will also take note of this aspect. Because regularization means you are putting somebody into a cadre. And if you just put all sectional assistants, because I think the sectional assistants scale of pay will be different from the driver, then who is going to give you the finance if you have all the sectional assistant regularized? If you don't have so many posts. So whenever there is a post, there is a scale of pay. So this cannot go in this manner. So it has to be on the basis there. So this, I think, this requires something to be taken out, or she will get your instruction. The matter being heard at length, this court seeks instructions from the learned counsel for appearing on behalf of the respondents as to why the petitioner has been placed at serial number 8 in the seniority list, although the petitioner apparently appears to be senior to the person at serial number 4. List the matter again on this Thursday for further consideration. Yes.
What's the direction, Your Lordship, to produce the
Again, you want to show your helplessness today. On the ground that your senior is not around. Is it? Are you going to show your helplessness that your senior is not around? Or are you going to do the matter?
There's a direction on this honorable. It's the attendance sheet from Mr. Respondents to yours.
Huh?
There's a direction from this honorable court to produce the state respondents to produce my attendance sheet.
To produce the
Attendance sheet.
attendance sheet.
Yes, I have served my service on.
Wash and set aside the letter dated 29/10/2020, direct respondents to grant extension and regularization of the petitioner's service as a Hindi teacher. Directly to release the petitioner's salary from 19 till the date. Where is that order? 29/10, Annex 11. Response to on the subject. Yes. What is your ground of challenge?
No one is stood up.
You are still holding?
No, no, no. But no one has picked up with the.
Now what do you want? This court should grant you an extension.
Yes, sir.
How can this court grant you an extension? You held the recruitment process?
Till the time when the respondents appoint someone in command. It's limited only to that extent.
How? That is absolutely within their domain. And why no recruitment process have been held?
Worship, since this petition has been filed on 25/11/2020. So because of the tendency of this fifth petition, initiated committee and refer to the petitioner. That's the petitioner. Because we have the highest respect to the majesty of this court. First, the matter is pending here. The order and direction of the dishonorable court is awaited. Your lordship, let me highlight before your lordship the short matrix of this case. Petitioner was appointed as a teacher, and in fact, it's an appointment order. Petitioner was appointed, and in fact, for appointment order.
Ad hoc. But that is not your ground.
No, no. Let me just highlight you the ground. Your
No,
lordship
no,
may
no.
kindly come to.
Let's see the impugn order. The impugn order categorically says what is the grounds.
Lordship.
Kindly come to page 26 of the petition.
Yes.
But why did you allow him to work?
Lordship, number one is to set aside in quash that Indian order. Number two, direct the respondent to grant extension and regularization of the
No,
petitioner.
no, no. I'm not on that. I'm coming to page 26. Page 26
That
of
is
his
why
report.
your lordship.
Yes. This is the one he is challenging.
This is what they are challenging. But now, your lordship, the petitioner was found, his appointment order was found to effect by the primary investigating agency of the state, that is State Vigilance Commission, in its report on 7 July 2011, your lordship. Lordship, you will find an annexure 1, page 9 of the state conduct. The findings of the state primary agency, that is State Vigilance Commission, Directorate of Vigilance and Anti-Corruption, Nagaland.
Page 7.
Page 9 of the state contract.
Your affidavit number 4 and behalf of respondent number 1 and 26 as per direction of this court.
No, lordship, not that one, the main one.
Yes, yes.
It was filed on
Page 9.
15/11/2021. 2 years back.
Appointed against creation of a man fake post creation order. Signature of Pukia in the appointment order confirmed forged, not genuine.
Lordship, you will find in page 10 the name of the petitioner and serial
780.
780.
Then have you initiated criminal action against
No,
them?
no action taken.
But this was done in 2011.
Because of this pending.
No. The pending is recently. But this was done when? When did you find out? This thing, annexure 1 is dated?
No, because of that, your lordship, you come to the page 11, annexure
Yes.
2, page
No,
12.
so.
We have investigated, we have made an inquiry.
No. You see, this report is of 7/7/2011. Okay?
Yes.
When did you release it?
Because of that finding, lordship, we have made an inquiry. Because of that finding, the department has made an inquiry. Your lordship will find the inquiry report in page 40. It was submitted on 10/3/2021. Because of this inquiry report, your lordship, the Indian dated 29/10/2020 was issued, your lordship. Because of the report made by the inquiry.
So
Departmental inquiry was there. And because of this inquiry report, we have made this, the Indian dated 29/10/2020. That is the thing.
But this happened in 2021. And when did you release him? 2019. Why from 2011 to 19? Why did it take such a long time? Why did you allow him to work for 8 years after knowing it, that there was a bogus?
I cannot explain for your lordship properly that lapses, but then he was working in a very interior area. That means after a loan, it has to go like that. So there was some communication gap in the official correspondence, maybe, or otherwise. The lapses on the part of the.
Mr. Townsend, the moment you say or, this court has to.
Or the
go
lapses
into
on the part of the
presume.
officers of the Moon town. Because we have officers in Moon district. education department is there, district education officer is there, sub-divisional education is there, full of different categories of the school. So because of that communication mistake, it was that. We admit, as per the attendance register, which I was directed to produce by this honorable court. And it is clear that
Now,
he was shown, petitioner
no,
was shown presented from 2015 to 19 as per this register.
absent. He was absent.
He was there, he was there.
Where?
Since 2015 to 2018. He was there.
He was working.
He was working.
And
That-
did you,
that-
did you
that
pay him
second-
his salaries? You're paying him the salary also.
We are
Be
paying the
happy.
salary.
Without a job also, we on a fake document, you have enjoyed so much.
After that, my service was generated. Because of my service, I have been sent for in-service training. Post-transfer. Because of that document. As per the registration.
You were transferred.
Yes, post-transfer is amount. I was sent for in-service training also. And I was sent for election duties in the course of my service career. I have not been an forced document like the education.
Are you by any chance inferring that there was something wrong in the election duty because of a person illegally appointed?
But the department has recognized me, sent me for the in-service training.
But tell me, how
Cross
can
transfer.
this court direct regularization?
Not because at least my service may be extended.
How can this court grant extension in view of this inquiry report? With this inquiry report remaining, can this court direct? Tell me. Unless you set aside this inquiry. Page 14.
Okay. You are knowledge to independency of this week.
With this inquiry report, can this court, they grant you that, okay, let him be extending? This is a court of equity. Regularization to this court can't give in view of the fact that, so that really goes. Second is of the extension. How can this court grant an extension after this inquiry report? And the director vigilance report also, which says it is bogus. How can this court do that?
He's the sole breadwinner. It is a consideration.
Huh?
He's the sole breadwinner of the family. He has a family to feed.
So somebody who is otherwise legally appointed, ought to have been appointed, he would also have been a sole breadwinner. And apart from that, another most important thing in the inquiry report, I don't know whether you have read it or not. All the 200 posts of HT teachers are filled up. On what basis will they keep it now?
The post which I was serving, to my knowledge, none has been appointed.
Obviously, that is a fake document. How can they appoint somebody? They have to create a post. They have not, that is their thing. That we have never created that post. I think without challenging the
Yes,
inquiry
Lord.
report, you can't.
That is one technical hurdle I have to overcome, Lordship.
The learned counsel appearing on behalf of the petitioner submits that in view of the subsequent developments which have taken place pursuant to the filing of the petition, more particularly the inquiry report dated 10th of March 2021, the petitioner may be permitted to withdraw the instant petition. However, he submits that the petitioner, that the withdrawal of the petition should not prejudice the petitioner to avail remedies against the inquiry report and other consequential reliefs thereupon. Taking into account the above, the instant petition therefore stands closed on withdrawal. Interim order, if any, stands vacated. This court, however, observed that the withdrawal of the instant petition shall not prejudice the petitioner to assail the inquiry report and seek other consequential reliefs, if so otherwise permissible under law.
Item number 45.
May I please, Your Lordship? Your Lordship, the petition is paying for regularization for pensionary benefits. The petition was serving as work judge, was appointed as work judge Chokidar under the office of the executive engineer in February of 1986, and thereafter he was promoted to work judge Jugali scale of pay on the 29th of August 1987. Then after that, he was given scale pay, annexure 3 scale pay. The Lordship, before annexure 3, there's annexure 2 where he was promoted to Jugali on scale pay. And then after that, he was.
You were regularized
Lordship, I was not regularized.
at any point of time.
No, Lordship. I served for 29 years. To be precise, it was 28 years, 10 months, and a few days. And then after that, I was released by order dated 10th February 2015 with effect from 31st December of 2014. And then only after that, I made a representation to the executive engineer for regularization of my services. That was in. The representation is not dated, but it was.
But madam, tell me, how can this for direct regularization that too prior to, when at that point of time, when you retired, there was the 73 did not come in. 17/3 2015 did not come in.
Yes, Lordship.
But how can today, as per that earlier thing, you never applied? Is it required to be applied as per the 22/9/2004?
2004, Lordship, it does not speak of.
Because you have retired prior to the 17/3.
Lordship.
So under such circumstances, you will be regulated under the 22/9. 22/9, if you are there, what is the parameters? You have enclosed the 22/9 in your petition?
Lordship, it's in the documents affidavit. Page 7 of the affidavit. Lordship, if I may be allowed to read the conditions.
Annexure?
Annexure A, page 7 of the government's affidavit.
Yes, sorry, yes.
The conditions are as follows. Each department having work contain a list of work charge employees in various categories in order of their length of service. Regularization of work charge employees will be done against available regular vacancies. 3% of all regular vacancies of similar nature arising in a year will be reserved for regularization of work charge employees, and the remaining 50% will be filled up as per normal rules of recruitment. For work charge employees will have the right to be considered first for regularization against 50% of all future vacancies of similar nature in the department for which they possess the requisite qualification. Such regularization will be considered on the basis of seniority cum merit. This means that the senior most work charge employee in the relevant category will be regularized subject to his or her fitness for the vacant post. 5. In case no work charge employee is found to be suitable for regularization in terms of the above clause 4, the department will obtain clearance of PNAR department before making any fresh appointments against the quota reserved for work charged employees explaining the circumstances cannot be.
So you are not considered in terms with this.
No, Lordship.
Well, but is it required for you to apply?
No, Lordship. There is no condition like that I have to apply for.
Yes, government, what do you have to say?
We're saying that.
He has missed the bus.
Sorry?
You have stated he has missed the bus.
Yes, Your Lordship. In the sense that, Your Lordship, during his time in the service, Your Lordship, he was not under the zone of consideration.
Why?
When he retired, because he was not the senior. And also, Your Lordship, this case is squarely covered by Alinda's case, Your Lordship.
How?
Division bench matter law.
How?
Your Lordship, here,
Lordship, if I may.
No, this is a different case. This judgment is different. This is another one. Here is a case,
in Alimba's case also, Your Lordship, after retirement, after serving for 27 years, Your Lordship, they approached the and Your Lordship, it may be interesting to know that the council in Alimba is the same, Your Lordship.
Huh?
It's the council.
Lordship, we appeal.
And they might
Alamba, Your Lordship, it was your judgment.
whose judgment?
Yours. It was a division bench.
Uh-huh.
Your Lordship, Alamba versus State of Nagaland versus Alamba. Your Lordship, however, that judgment has been overruled by 35 of 2022. Lordship, if I may submit.
Where? How can it be overruled?
Lordship, that in this judgment, the bench has held that the case of justice Alamba is per imperium. Lordship, you can find it at page 21, paragraph 21.
Page, paragraph 21.
Page 21, paragraph 21. There were similar matters that were decided before this court, way before State of Nagaland was. And during that time, so there are several cases
Where? Yeah, say that the Alamba is there.
Lordship, there is no name, writ appeal 27 of 2022.
Huh?
Writ appeal 27 of 2022. Lordship, the name of the case is not given in the paragraphs. But if you look at paragraph 21, that in respect of the decision of the division bench of this court in writ appeal 27 of 2022, that is state versus Alamba. The learned counsel for the respondent submits that in view of the two earlier division bench of this court, writ appeal 12K 2009 and State of Manipur versus Iboha Singh, reported in 1997 to 0209, the decision of writ appeal number 27 of 2022 is per imperium in view of the law laid down by the Supreme Court in the case of Pranay, Sethi and others.
No, this is a submission.
Lordship, this has been deliberated by the bench.
Let's see.
Discussion, it comes under the heading discussion.
These are all submission. Having considered the year here, certainly on interpreting the beneficial discussion should be one alembic soon.
Copies of writ appeal. If I may be allowed to submit a brief list. It has the, most of the.
No, it does not say so. It does not say so. But anyways, what did Alamba hold?
Alamba held that, Lordship, I believe it deliberated mostly on the OM.
No, Alamba, you see how the difference in Alamba, how can Alamba be brought out here? You see, kindly see here. He continued until his retirement on attaining the age of superannuation with effect from 30/11/2018. In this case, the petitioner retired on 30/12/2020, 2014. So as on the date on which the petitioner had left the service, 17/3/2015 was nowhere in the scene. How do you bring in Alamba? Isn't it? Why you are
In
making
that
this
case,
thing?
Lordship, this new judgment will not be gone into.
Not necessary, but the simple question is, as on that day, you were required to be considered.
Yes, Lordship.
So irrespective of that, whether you could have been considered in view of the policy.
Lordship.
Now the question is, at that point of time, 50% was to be taken into account. Now, whether they address that aspect of the matter or not, if not, this court will direct them to address it. That's it.
Lordship, we have, seniority list with me as of now, but, the government affidavit in page 3, paragraph 5, the other half of the paragraph.
Paragraph 3.
Paragraph 5, page 3.
Ah.
The other half is.
It may be pertinent to mention the petitioner was upgraded to scale pay by so and so. And as such, his seniority as Ugali pay scale will be counted from the date the petitioner was. Though the petitioner could not be regularized as the petitioner did not come within the June of his retirement. At the not relevant time, the petitioner was then office was in effect and regularization was done purely on seniority basis. See, they also say that the deponent fell state that directly the result the deponent considered the representation, however, and he was not the senior most amongst the Jugalis before his release from service. The case of the could not be considered.
Office order 26/6/14. You have mentioned 26/6/14. I was updated to time scale on 29th August 1987. So if they are, Lordship, I don't know how they are counting the, Lordship, my apologies. Lordship, if they are to count my seniority according to that, if they are to count my seniority according to the date I was upgraded to scale of pay, it should be from 29th August 1987, and not as they have reflected in the.
We do one thing, madam. We direct them to produce the seniority list on the basis of which they are making this. That is a better option. And we'll have a look at it. So upon hearing the matter at length, this court finds it relevant to observe that the reason why the petitioner hearing was not considered to be regularized in terms with the office memorandum dated 22/9/2004 was that the petitioner was not did not come within the zone of consideration as per the on the seniority basis. This being the categorical stand of the respondents, this court is of the opinion that the seniority list prevailing at that point of time, when the petitioner was about to retire, be placed before this court. The petitioner had retired. Be placed before this court. When, madam? Twenty-nine? Okay, this is the matter on 29th of February 2020. That is the only issue. These things don't come. Because Alembic is also not there, neither because this is also not really. Because Alembic was a case where he retired on 2018. At that point of time, he did not. In the meantime, 17.3 has stepped in.
Yes,
With
sir.
17.3 coming, he had to have the 30 years. You want the books?
No, Lordship.
Huh?
Yeah.
You can use it on the rough paper, on the back side.
Okay.
Yes, any more matters? Yes, any more matters? I think today I've done more.
Item 46, Your Lordship.
Item number 46.
Your Lordship, 3 weeks may be granted, Your Lordship.
Right.
Lordship, this relates to a minimum scale of pay, Your Lordship, and we have many.
Jagjeet Singh.
Yes.
In Assam, there is one order, Upendas. So there in Assam, there is an order to that effect that they have to be paid. It's a division bench judgment. That they have to be paid at the minimum scale. You want that? So madam wants to escape.
No, not escape, Your Lordship, just people also like in the Supreme Court and as well as them mainly scale of pay which are keeping on hold. So
Where?
3 weeks may be granted.
Where is it?
The matter like a similar matter is being considered, has been appealed in the apex court also.
It is before?
Apex court, Your Lordship. I have met, previously I made a submission also, Your Lordship, and due to that we have been extending the time.
This matter means
Similar pattern,
from
not-
Nagaland.
Yes, yes.
It has gone there.
Yes.
So some
Similar.
earlier court had decided they are
Some-
entitled to.
Yes, yes, that's why Your Lordship.
The state.
Yes, that state has gone for. I already make a submission and in light of that, like, we have been taking time. Your Lordship.
Where?
So I exactly remember the date.
SLP admitted.
Yes, Your Lordship.
Huh? SLP
It's
admitted.
pending, yes, it's pending, Your Lordship. That's what we are informed, we were informed pending. Outcome is not known.
Chalo, you do one thing, produce the date of the SLP.
Chief, I might have mentioned Your Lordship in the.
See the file, you then produce it on Thursday. So back on Thursday, on which it's so and so the learning council shall produce and then shall place before this court the details of pendency of similar matters.
We are to produce the SLP number, Your Lordship.
Now you produce only the case number, which is pending.
Item number 47.
Yes.
Lordship. Lordship. The matter is resolved. It will take only some maybe 20 minutes. Lordship.
20 minutes?
Lordship.
Okay, we have too much time today.
Lordship here.
What are you challenging?
Yeah, I am for invalid pension. Lordship. Invalid pension. I have my invalid pension was approved by the respondent attorney. So, Lordship, that's the case there.
What they have done?
Lordship, Lordship, we kindly, for more clarity, Lordship, we kindly come to this, my petition, page 17, annexure 3. And then This is the type copy logic, page 18. So this is
Has been
how,
approved by the director.
yes, Lordship, this is how my
Invalid retirement has been
Lordship.
approved by the director. You have released from the unit with effect from the form. Information may be submitted to the office. for procedure. This was done in 1991.
Lordship, I'll come to that, Lordship.
And
Now,
then-
after the approval made for my invalid pension, I have made an inquiry about my invalid. And then in 1995, I have asked, I have written one representation.
You have?
I have written one letter, I cannot representation.
Ah.
That is at page, the following page, page 19, annexure 4. Now, after that, despite of this, my invalid pension was not considered. Now, Lordship, to make the matter simple, dear reply, Lordship, stating that I have not completed 10 years of service, Lordship. So, Lordship,
So you're not given pension.
no, I have not given pension. Now, after that, after I admit that I have written one representation, that is page 20, annexure 5. So, Lordship, due to my unaware and then ignorance, I have not kept the reports, but through RDI, I have obtained all the legal documents, supporting document in regard to my appointment is at that, Lordship. Now, Lordship, after this representation also, they have not considered my invalid pension. So I approached this honorable court for claiming for this invalid pension. Now, Lordship, the state respondent, the main condition is also that I have not been completed 10 years. So my Lordship, my humble submission is that, see, as per this CCS rule 1972, in the rules 38, nowhere in that rules, it indicates about the length of year for invalid pension. That is first point. Now, second point, in the state respondent, here office memorandum, as per this in the reply, they have given one memorandum. Also, may I get to the state respondent reply? Lordship, additional affidavit in the position of 120. Lordship, we can turn to page 6 of the reply. So, Lordship, the main contention, as per this additional affidavit filed by the state respondent, page 6, annexure B. Here they are saying that I am not eligible for invalid pension because of less length of service. Now, this office memorandum was given on 22nd December 2015. So, Lordship, thereafter, on the earlier hearing, I have placed the amendment which was placed before the court as a matter of the courts. So, Lordship, I would like to place that reports.
Office memorandum.
Yeah, this office memorandum issued by this government of India.
12 to 2019.
Yes, 2019. Where it says, Lordship, thereby meaning, Lordship, by this office memorandum, it has been superseded by the earlier office memorandum which the state produced. Now here, in this office memorandum, Lordship, as categorically stated. Lordship. Now, I'm about to make a question. Subject is, this memorandum, draft central civil service, pension rules and clarification regarding that the science directed to say that group therapy and services pension rules have been amended by the purpose of the provides that the government which permanently is in for the service India may also be granted to subject of subject or after this permanent service of goods and was effective by the before.
So this is a clarification.
Yes.
So it being a clarification, therefore, it will date back to the original rule.
Lordship. Lordship. So
Otherwise, you have no other way. That has to be a submission.
my submission is that here by this notification. I
Have
will
you
take-
brought this on record by way of an affidavit?
Lordship, on the last, on this matter, now we are having third round of hearing. So I was allowed to place this record.
Mr. Khan,
Lordship.
I'll tell you why I'm saying.
Lordship.
You need a specific averment in your affidavit
Lordship.
that as this is a clarification, it dates back to the date on which the rule 38 and 49 had come into being. Put that on record by way of an affidavit. Small, short affidavit, just one paragraph, and enclose this. Then this court will take care of it next week and pass the judgment. But without doing that, saying anything, this court has, because there is no pleading, that it relates back to the being a clarificatory notification. See, what is being used is a clarificatory.
Lordship, yes.
Yes. You are the central government or not?
No, state government, Your Lordship.
Yes, tell me.
With regard to the clarification, it states the clause B states that there's a condition, Your Lordship,
What?
which states that the government servant should fulfill all other conditions mentioned in the rule, that is Rule 38, where it clearly states Rule 38 2 clearly states that medical board should be constituted and a medical certificate should be issued. Here, the petitioner does not have the medical certificate, Your Lordship. Medical board was never constituted.
Whose fault?
Your Lordship.
No, whose fault? Your fault. How could you have granted him on the invalid pension without doing that? In fact, prior to that, madam, kindly see your additional affidavit in opposition. Kindly see. This is the document on which you are relying on of 2015. Kindly see. In pursuance to this, in view of the position, page 6, in view of the position stated above, the following procedure may be followed while processing such cases henceforth. Prior clearance of the PNR department may be obtained before the government is released from pension service on invalid pension. Did you do that?
Your Lordship, the release order has been tempered also. Initially, the release order is stated as release from service on voluntary retirement, Your Lordship. Then it's been struck off and written as invalid. Now, if the official has done this, then it would have been countersigned, Your Lordship.
So under such circumstances, what does your record say? Have you taken that statement, your affidavit, your stand, that it has been tempered?
No, Your Lordship.
That means he is not because that is not your stand. You are on one hand saying that he is not entitled to invalid pension. If it is your stand out there that yes, the question of invalid pension does not arise because he has taken voluntary retirement, it's a different aspect. But you are not doing that. Can you take that stand now? That it has been tempered, this, that, whatever maybe, and all things, everything is gone. Now you come back and strike them at the initiative.
The condition is only that I'm not legal, was the best end of. But where is the rules permitted?
That is your basis all along. Because what happens, I'm telling you, when there is an invalid pension out there, you have to specifically mention. Why? Because you can't, a person, just for example, if he has had any difficulty during the course of his duty, he has been properly appointed and all, can you just throw him out? You can't. Therefore, it says, prior clearance of the PNR department may be obtained before the government servant is released. While forwarding the proposal for invalid pension, the referring department may specify the proposed date of retirement and shall also furnish the service book and medical recommendation. All invalid pension must be routed through PNR department. Now, this happened only in 2015, whereas this person has gone on retirement in 1991. So that was never a rule. So the rule has to be taken into account, Rule 38. Now, if Rule 38 says has to be 10 years, and there is a clarification being given by this is by the government of India, or you are going as per the CCS.
Yes.
If you are maintaining on the basis of the government of India thing, 38, and then you are doing it, this is the clarification being given. The moment it is a clarification, it dates back to that.
Then your lordship, as per the clarification, there's a condition, then what to do here?
Which one?
38(2), which says that all other
Fulfills
conditions
all
have
other
to be
conditions
fulfilled.
mentioned in the rules for grant of invalid pension. You have to look into it. All other rules which are there. That is your lookout. Look into it.
But it's been more than 30 years, your lordship.
So whether other rules are there or not, your basic reason why you are not giving him is because he has not completed 10 years. Now this is the clarification which is given. Now you may submit that this clarification is prospective. I give you time. Submit on the ground that this is maybe prospective. It cannot be applied in the case of him. And you submit that this will have impact on the date on which it is given. Because clarificatory notifications are to clarify what is it.
Lordship, 2015, that office memorandum, here is done is only.
Mr. Council, one has to also appreciate one thing. Till 1991, you woke up in 2021.
Lordship.
Then?
See, Lordship, I have met in 1985. My first representation asking for my invalid pension was way in 1985. Thereafter, on years saying that I'm not entitled for this invalid pension because of less
That happened in 1991.
Lordship.
Then what were you doing till 2021?
And then
you have spent half of your life with that.
Lordship.
And what is your age now?
Lordship.
'73.
Lordship.
In 2021. Why do you need pension now?
And then Lordship, see.
Another 3 years, 74.
Lordship, I'll come to that lapses, Lordship. See, I'm claiming for my right, not affecting the third party, Lordship.
Not affecting the third party, no. The government is also a third party.
Lordship.
Why didn't you challenge from
Third party in the sense,
1991?
Lordship.
Why didn't you challenge from 1991? Certain things could have been done. Isn't it a pure case of delay and laches?
Lordship, that is the Lordship. I'll bring that.
Or that person one day came to a cup of tea to meet you and you gave him a good idea.
Lordship, for that I'll bring some authority for the SEC.
Huh?
For that, on that basis, Lordship, delay. I'll give that one authority. Lordship.
Okay, madam, we'll do one thing. We'll have it on Thursday.
Not your lordship.
You
on
only
Thursday-
submit on that. Nothing, I don't need reports, nothing. Only to that effect. That this first is cases of delay. Mention whatever may be. This is a delay. This court, can this court exercise after 1991 and till 2021? 21 and 9. If we had gone for this under 17/3/2015 notification, he would have been what they call regularized.
Yeah, Lordship. But I was appointed on regular basis.
You could have very well joined work charge employee or casual employee and got a regularized order out here. When- Anyways, you do one thing, you'll have it on Thursday only on that aspect. On the question of delay. Secondly, as to whether it is permissible, whether it will be prospective. This thing. So then we'll have to look into Rule 49 also. Because this is on the basis of Rule, this is a on joint reading of Rule 38 and 49.
And then Lordship, for one more submission. Here, 2015 office letter, it was issued by the state government, saying that under this CCS rule, that the 10 years length is required. But nowhere in the CCS rule it is mentioned about 10 years as per the 30.
But whatever may be,
and
that happened only later.
And then Lordship, the second clarification that is issued by the government of India. So this is the 2019 OM, it overruled, and then it clarifies on the length of service. And then the whole condition. of
Here the pension
affidavit-
is given under what? The CCS. You have adopted that. So Rule 38, does it say anything about 10 years?
10 years is mentioned in Rule 49.
But Lordship 38 is 48.
38 talks about, defines the invalid pension, and 49 talks about the qualifying years.
Where will I find that?
Lordship 39 deals specifically with regard to invalid pension. 49 deals with a normal type of pension.
Where? Excuse pension. Yes. But did you get half of that?
Lordship, see.
Did you get the service gratuity?
Lordship, I'm asking for invalid pension, whatever it is.
I'm asking you, did you get the service gratuity?
Service pension.
Service gratuity.
Lordship, I'll get according to my end of service, I mean, years of.
Did you get the service gratuity? If you have got it, you have taken it, you are happy for 30 years, and then you file a petition, is it permissible?
Lordship, all dues were paid to him.
Then?
Lordship, I'm asking for invalid pension.
Understood, but then also you have accepted that.
And
why
then
should
Lordship-
this court?
Lordship, this section 30, Rule 38 deals specifically with this invalid pension, whereas, if I'm not mistaken, Lordship, 49 deals with a normal pension, Lordship. It is nowhere related with the 49 and then this 38, Lordship. This is 49 is a calculation of the pension, how much amount if I complete 10 years. So this 49 and then 38 is completely different.
We'll hear you tomorrow. Finish it.
And then Lordship, for this license and delay.
Release the matter tomorrow at 2 p.m. 2 p.m. Yes.
Yes, please, Lordship, here, I am asking for land compensation. Land compensation. See, Lordship, a high school was established in our land. And then the school was donated by different landowners. Lordship. Now, I'm also one of the landowners. Where this
Has the land been acquired?
Already acquired. Lordship.
When?
Since long back, Lordship, 1975.
What?
Lordship.
Again?
Lordship.
Another, where do you get all these old cases?
No, Lordship.
No, one is of 1991, next is 75.
Lordship, I'll come to that, Lordship. See, Lordship, see, after the establishment of the Lordship, I may be allowed to submit a short submission, Lordship, short submission of that, whether I may able to convince the Lordship. See, Lordship, we have given the land for establishment of the school. And then it's a combination of different landowners. And then the other landowners, they got opportunity of fourth grade appointment, this and that. Whereas I was never given any.
You gave it free of cost.
Lordship. So I have written representation. And
when?
Lordship.
1975.
No, Lordship.
Then?
Lordship, may kindly turn to my page 15, the next one. This was
these type of requisitions requires to be dismissed with cost, huh?
Lordship, it was
spoiling the judicial time. Spoiling the judicial time. Page
15, Lordship. Page 15. Yes.
Where did you give? 2021.
Yes. So, Lordship, see, I have asked for appointment for any foreign appointment because I have given the land. I'm saying that.
But was there oral agreement?
Oral agreement, yes, oral agreement. There was oral agreement because we have given the land.
Then why you are not saying that there was an oral agreement?
And the Lordship.
On the other hand, you are asking for compensation.
No, Lordship, I'll come to that, Lordship. And the Lordship, my application was forwarded.
No, Mr.
This is the second.
This is a case for dismissal.
Lordship, this is the second.
How many times you have appeared in this matter?
Lordship, this is the second petition.
How many times you have appeared in this?
12 times.
12. 12 into
Including today,
make it 5,000. 60,000.
Lordship, I may be allowed to say.
Plus, you have filed affidavit?
Yes, I have.
Yes.
Affidavit is 7,500. So 57,500 is the cost.
Lordship, I may, if
Dismissed with cost of 57,500.
Lordship, I may allow.
No, nothing to it. This 75, somebody takes your land, now you are asking for, in 2021, you woke up and say that you want somebody's job. Okay, you did the job and now you are asking for land compensation?
Because my land is a private land, Lordship. So it cannot go on the paying compensation because as per the.
Mr. Counsel, better off withdraw and approach and file whatever you file with the district administration, they may help you out something. This court only can do one thing, dismiss with cost of 57,500.
I cannot keep my land forever, Lordship, because it's a private land, my private land.
So what? What were you doing all this while? You see, 1975, as I could see that today, I disposed of another matter, I could see that there is a notification of 5/3/2018, wherein it categorically mentions as to how these type of things can be done. If you want to do it, you have to approach the deputy commissioner out there saying that, you see, kindly give me a job. And then the deputy commissioner, if you have an oral agreement or not, because otherwise it will be deemed that you have given it free of cost, because that was the tradition. Know that. Say that you have an oral agreement, there is one job out there, give it to me, something to the effect. But these type of petitions is dismissed with cost of 57,000.
The Lordship, in the reply also they said that as and when the vacancy arrests, my application that's it in the.
Where?
state respondent affidavit.
What do they say?
They say that my application will be considered as and when vacancy arises.
Vacancy arises. Very well. Go there. Very well. In view of their affidavit, you don't want to press the instant repetition. However, shall wait for that. Better off. It never matters. You can't help it. Where's that affidavit?
So Lordship, in that view of whether I may be allowed to take some instruction from the client. Whether
For what?
Because I need that.
He cannot be adjusted against the vacancy area. It is pertinent to the policy memorandum dated demand are to be followed and while examining the claim of demand, further to state that on perusal of the no oral ER before a competent authority is found. See? You take up that issue. They are not going to give it to you. They categorically say that there is no agreement, and it is only when there is a written agreement as per 3A and 3B, there has to be an oral agreement which is proved by witnesses. Tomorrow, 2 o'clock.
Lordship.
2 o'clock.
Lordship, I may be allowed to take some instruction from that client.
That is what I'm saying. Instruction for that. Otherwise, I was about to dismiss. Tomorrow, 2 o'clock. We dismiss it with cost. Only
Lordship,
take your instruction of 57,500. 12 times.
Lordship, well, you keep 1 week time, Lordship.
No.
Because my client is
You see, tomorrow I have other matters also to hear. I'm done with this. Matter is over. So I just approve. You have encouraged this person to appear. So you just take your point as to whether you are going to pay the cost or your client will. Somebody has to pay the cost.
See, Lordship.
Why is he appearing? He has to appear. Something has to be done.
Lordship, see, my last submission.
Yes.
See, till now, the land, of course, I have given free of cost. But till now, the government has not given it. Neither appointment. And then still, the land belongs to me, according to my land. What is the private land?
So you don't, have you not donated it?
And then there's a discrimination. I was not given any sort of opportunity since one time.
So what? You gave it free of cost at that point of time.
But usually this we are in other activity we engage you to get some corporate appointment.
Your forefathers never thought of that intention. You are now thinking about that intention. In the earlier case also I found that the forefathers never wanted anything. Now the people have become clever. Yes, why not take the benefit of these government things?
And then a private land cannot be not free of cost. And then in 2018 also, the state government has
So that happened only in 19. There's a in that 5.3 it has been mentioned, 2001, 2005. From 2005, that is the year that no land will be acquired without payment. But your thing was done in 75. So 57,500 tomorrow. You just take your instruction. You are going to pay all your clients.
Much of it.